So. Okay. Okay. Wait till break. Okay. I will. Thank you.
So I wrote that to the guy and I sent him the letter.
Good morning, everybody. Welcome to House Education. It's almost like we never left this place.
Yeah.
And so, as I mentioned to several here, I just enjoyed the drive down today because I had Glenn Campbell and Ann Murray right with me, and it was very comfortable and relaxing. For all those that are here, I want to make a reference to what we have for bills coming up on the Wednesday of this week. And in the calendar, it indicates that there is a bill that we've already execed. And so obviously, we're not going to be executing that particular bill. That is 1397. That's the last bill identified for action on Wednesday. That's already been taken care of, so that will not be discussed. We've already done it. All right, so what I'd like to do now is get into the bills for today. We have the first bill on the docket is HB 1312, requiring parental notification of student health or well-being and certain curricular by school districts. Welcome, Representative.
Thank you. Thank you, Mr. Chairman and honorable members of the Education Committee. For the record, my name is Representative Christine Perez. I'm from Londonderry. I represent Rockingham District 16. I'm here to speak on behalf of Bill 1312. It's a kind of a two-part bill, an act requiring parental notification. This bill will expand the notification that prohibits policies that would stop the notification about students' well-being. I want to direct you to the technical advisory that I had passed out to all of you. This was issued by the Department of Education on May 12th, 2023. This advisory provided guidance to educators when discussing issues related to human sexuality outside the contents of health and sex education. It reminds educators that parental notification is law when discussing human sexuality in any course context. For example, English language arts or other areas of study. This bill would add the word any in front of the curriculum word to clarify. It will also expand the definition of course material to include sexual orientation, gender, gender identity, or gender expression, and that not less than 2 weeks' notice will be required. Now, in doing some research for this right in my own town of Londonderry, I found that their notification policy was from 2012. As far as I'm concerned, it might as well have been 1812. It had not been updated after the law, it became law in 2017 that 2 weeks notice of parental notification had been required. It does not prevent an educator from answering any questions in the classroom or sharing incidental information. For example, if I was a teacher and someone asked me if I was married, I certainly could say I was married. If they asked me if I was married to a male or female, I could certainly answer that. It does not exempt that type of thing. It does exempt actual teaching outside of health and sex education. There's another part of this that would also, and I feel it's a protection actually for teachers, it would require that the schools may not adopt policies that would stop personnel, may not adopt a policy that would stop personnel from notifying a parent about a child's mental, emotional, physical health or well-being, sexuality, or changes in services. So if I am a an educator, and I feel it is very important to notify a parent about an issue that is going on with their child in any of these areas, the district cannot adopt a policy stopping me from doing that. It also allows them to have policies that information could be withheld if a reasonably prudent, and I did look that up and research that, believe that the child could be harmed by that information being given out. So I looked up reasonably prudent, and basically it's a person seeking in good faith to perform a contractual obligation. So if someone in good faith felt that if I said something to a parent in that child's specific instance, there could be a possibility for harm, there would be a policy that would say that I could withhold that information. So I believe that if you read carefully the technical advisory that came out, basically it is enforcing this bill. It's saying that you cannot teach things in art or in English or in other subjects. And if you do, it needs a parental notification of 2 weeks. So, and I'm willing to take questions. I hope I can answer them.
Thank you very much, Representative Perez. Are there questions from the committee? Yes, Representative Woodcock?
Thank you, Chairman-elect. Good morning, Representative.
Good morning.
I just want to be clear on the clarification made. So if I am teaching a literature course or a world literature course,
Right.
and I want to reflect back on the some of the art and some of the parts of the story or Shakespearean story, something of that nature, I would need, and it has some sexual overtones or innuendos or direct fact in it in the literature, I would have to receive 2 weeks notice from the parents. Is that correct?
I knew that was going to come up.
Good.
And my answer to that is, many years ago in middle school, I used to go in and talk to the young girls in middle school. Of course, this is many years ago, about what was normal and what was not normal. It's a tough time to be in the middle school, and that it is all right, and it is all right. And one of the things that I brought out was things that had happened in the past. For example, if you were not voluptuous way back, you were considered poor because you couldn't afford food to be
Sure.
overweight. This is not going to stop that type of thing. I mean, if you are talking about human sexuality as we know it and not trying to push a subject, this won't cover this. This is human sexuality, gender identification, specifically as we know it in 2024. I believe.
Follow-up?
I believe.
Thank you, Mr. Chair. I just want, I didn't really get not the answer I wanted particularly, I didn't get the answer with my question, which was a non-health sexual education instruction. I'm talking literature or something, history,
Okay.
Particularly back or Shakespeare, and it's going to involve dialogue from the script in Shakespeare or theater. So would those folks, those teachers need to get the 2 weeks parental notification in English?
I do not believe so. I think that the district could look at the syllabus and look and see what it is. The syllabus that we have in Londonderry right now is going to be updated, because I'm going to push it because it's very vague. I would think that would be could certainly be if the school district approves the syllabus and what is in that syllabus.
Okay, thank you. Thank you, Mr. Chair.
Further questions from the committee? Thank you very much.
Thank you.
I'd like to invite Giles Bissonette, ACLU. morning.
Good morning, Mr. Chairman. How are you?
Fine, thank you.
Thank you, Mr. Chairman, members of the committee. Gilles Bissonnette, I'm the legal director of the ACLU of New Hampshire. We oppose this bill. I want to go through kind of the two, what I think are kind of very different and distinct components of the bill. The first being the changes to RSA 186.11, Roman numeral 9C, which is the 14-day notification requirement, and also then provides an opportunity, of course, through that notification period to allow students to opt out. I think with respect to that first section of the bill, I think there are two problems with it. And I think the first is, I think we're targeting, in many ways, LGBTQ plus students. And I think the second problem is that is impractical. And for many of the reasons that I think were articulated in some of the prior questioning before my testimony. So first, I just want to be very clear, at least how I read the bill and what its scope is. Maybe that's not the intent, but it's certainly how I read it. This bill expands the scope of that 14-day notice and opt-out period, not just to sexual education, but it goes beyond that to any type of curriculum or instruction or program of sexual orientation, gender identity, or gender expression. So we're taking this statute, we're now expanding it far beyond what I think what was its intent back in 2017, which was to address sexual education. And I would note that notwithstanding the Department of Education's recent technical advisory, they issued a technical advisory right when this 2017 law was adopted that I think made clear that this was a statute limited to sexual health. So this is very, very expansive, and I just think we need to be clear about that. And so in so doing, I think it is targeting and stigmatizes any instruction concerning LGBTQ plus people, and I think it sends the message to those students that their identities are something to be shunned, feared, and potentially even chilled with respect to instruction. And I just think that's a concerning message, and I don't think that's a message that we should be sending to those students in our schools. But I think the second concern is that it is impractical. Again, when you take this outside the context of sexual education and sexual instruction, you are taking this right into classrooms like history, English, social studies. And of course, in those classes, there's going to be discussion about sexual orientation. There's going to be discussion about gender. You might talk about the 2015 marriage equality decision. You might talk about the 1848 Seneca Falls Convention, which addresses directly gender. You might talk about the Stonewall incident of 1969, all of which I think plausibly are covered by it. Again, may not be the intent, but I think when you read the bill, course, materials, instructions on gender, sexual orientation, that falls within its scope. So I just want to express those concerns. Lastly, with respect to Section 2, I do want to convey the real concerns that we have about potential forced outing. So we believe that a school district policy, of course, should not categorically prevent a teacher from making a determination to disclose such information concerning gender identity, for example. But of course, school personnel should never encourage students to withhold information from parents. But problems arise when school districts are forced to implement policies that mandate disclosure, taking away this discretion. And that is what I fear Section 2 of this bill would do. And our position is that students learn best when they feel safe to be themselves, with their fellow students, with other teachers. But this bill, in our view, would drive young people away from trusted adults with whom they may feel more comfortable discussing sensitive subjects, especially if they're going through the process of preparing themselves for how to have those discussions with their parents, which is what we do as young people, right? You know, as we're grappling with certain things, we talk to our friends. Sometimes we talk to trusted advisors to figure out how to even not only kind of recognize what's going on within us, but figure out how to best broach that with our families. And I think this actually interferes with that in many ways. So with that, I'll conclude our testimony, but for those reasons, we oppose this legislation.
Thank you very much. Are there questions? Representative Hall, Damon? He's not even here.
Thank you. Thank you for taking my question.
Thank you.
Could you comment on how you perceive both parts of this proposed law in terms of its legality on a federal level?
Yeah, I think this will come up more obviously in some of the later bills. Today, I think there are certainly some legal concerns on the Title IX to the extent that these bills target and discriminate against individuals who are trans folks, which are protected under federal law and protected, of course, too, under our state separate laws. So those are real concerns. I think what I'm trying to do here is, in addition to all of those concerns, kind of bring this back to just the humanity of these students and what they're going through, number one. And number two, just try to, in my advocacy, just try to get the committee to think practically just about how this would work, right? If you're an educator, how do you comply with Section 2, if in response to questions that you may get from a student or even a parent, and also with respect to Section 1, like just what's covered if there's going to be any reference to gender and sexual orientation. And I just think for many reasons, not only is this unworkable, but also, again, we have separate concerns just about the targeting of these community members. Thank you.
Thank you. Further questions? Representative Cordelli?
Thank you, Mr. Chairman. Thank you for being here.
Thank you.
I just wanted to go back to your comments about Section 1 and what courses this applies to, because the topic heading for 9C is adopt a policy allowing an exception to specific course material based on a parent's determination that the material is objectionable. It does not specify there that this is related to sex education specifically. And then it does list down in lines 9 and 10 in the original bill, sex education, human sexuality, and so forth. But I'm not sure how you come to the determination that this whole section relates just to sex education.
To me, I think that's clear when you look at the legislative history and intent behind the 2017 law here, which is what this is amending. And I think also reflective of that, you could just look at the Department of Education's 2017 technical advisory that they promulgated to school districts after that 2017 law was enacted. And what they said is, quote, "It is important to note that the legislative intent of HB 103 does not apply to literature or other content that might have or be perceived to have sexual content." That is what the DOE said in 2017. That is, I think, what the legislative intent was back in 2017. This fundamentally changes that and runs completely contrary to it. And I just think we all need to know that that is what would occur if this were to be passed.
Thank you. Representative Ford?
Thank you, Mr. Chair, and thank you for taking my question.
Thank you, sir.
I think we're all concerned about this issue because we're all acutely aware of how sensitive the subject is in communities. I once lived in a community.
Can
that
you
was-
get to a question quickly, please?
I am, but I have to give you the information before I can ask him the question. I lived in a community that was evenly divided between Roman Catholics and fundamentalists.
Sir.
They were not in favor of discussing these subjects in public. And yet my son asked a young girl out to date, regular junior high school activity. And she spat upon him because he studied art with a man who was homosexual. And she then said, "I don't date," and she used a disparaging term for homosexuals. She had concluded that because he studied with that teacher, he must be. Now, how does the school deal with that kind of response?
I don't know. And I think it's case by case. And I think one of the things that we have concerns about when you have policies like this, right, when you essentially have categorical mandates, is that it takes that case by case determination away from school districts. So I'm not going to pretend like this is easy in every instance. But that is why we are precisely concerned about mandates, is to provide that discretion for districts. I mean, we do not, I mean, as I said in my opening remarks, don't advocate for in every instance that this information not be disclosed. That's not our position, but that it is something that, should be left to the discretion of school districts in consultation with administrators.
Thank you.
Representative Dry?
Thank you, Mr. Chairman, and thank you for taking my question.
Thank you.
So I'm trying to reconcile your last statement about they shouldn't make a determination about disclosure with the JBAB policy that our school district has adopted that says that school personnel should not disclose information that may reveal a student's transgender status to others, including parents and other school personnel, unless legally required to do so, or unless the student has authorized that disclosure. So I'm trying to, they seem to be at odds.
Yeah, I'd have to look more closely at that policy. The policy that I have more familiarity with is the one arising out of Manchester, which is not a mandate for all the reasons that I articulated. Again, our position is that a school district policy shouldn't prevent a teacher from making a determination to disclose such information, that it is discretionary and case by case, and that's what I've advocated, and it's not a new position from our office.
Representative Lekes?
Thank you for taking my question. It seems like what you just said is exactly what's in this bill. So I'm not sure why you object to this bill, because it's laying out that a teacher can use her discretion and that the school district can't say not to. And
Oh, sorry, I didn't mean to interrupt you.
could you explain to me?
Sure, that's not how I read this bill at all, in fact. And I think that is the underlying concern that I have. There is a carve out for abuse and neglect situations. I think the concern, obviously, that we have there and why that doesn't cover all of our concerns is that you can easily imagine where a school maybe would not necessarily have an indicia of something that met the standard of abuse and neglect, but there could be other indicia, that might lead a district to decide that it may not be appropriate. So I just think, again, these are local decisions, local school district concerns, and that's why I just don't think this is really ripe for adjudication at the state level, and you should allow districts to address this, but not through mandates that would be imposed by school policy under this bill.
Thank you. Representative Balboni?
Thank you, Mr. Chair, and thank you for taking my question. So in reading this bill, is it your understanding that if an English teacher was taking up a unit on poetry that dealt with the works of, say, Allen Ginsberg, would that, because of potential issues that might arise with conversations about the poetry, is it your understanding that the teacher would have to give a 14-day notice?
If there's reference to gender, sexual orientation, gender identity, I mean, I think the answer is plausibly and quite probably yes under this. That's my interpretation, at least.
Yes.
So could this create a lot of confusion for teachers in terms of trying to put together curriculums and what poems or what material that they're going to present in the classroom?
I mean, I think that's kind of goes to the impractical argument that I'm making. If I'm a teacher, I'm looking at this, I just don't think, particularly in an English class or a high school history class, I'm just not going to know how to deal with it, to be honest with you.
Are there further questions? Thank you very much.
Thank you, Mr. Chairman.
You're welcome. Amy Manzelli?
Good morning, Chairman Ladd, members of the committee. My name is Amy Manzelli, and I'm here testifying this morning on behalf of myself and my husband, Chad Trammell. We are residents of Pembroke, and we are here today to strongly encourage you to vote ITL on 1312. We have shared our family story of our 14-year-old transgender daughter, Iris, and so I'm going to skip over that part of my testimony today, though it is in the written testimony that I'll hand in. Beyond our family's personal story, we wanted to share with you how that story fits into the context of our joint shared American history, which I have previously shared also, putting together some of our key historical United States Supreme Court cases, Brown v. Board of Education, Loving v. Virginia, Reed v. Reed, Obergefell v. Hodges. And just like our daughter Iris, the plaintiffs in these cases, they weren't dangerous. They didn't need to be excluded from the conversation. Indeed, these plaintiffs, just like my daughter Iris, they only wanted to live their lives with the freedoms Americans enjoy under our nation's great laws. And the United States Supreme Court found the laws in those cases prevented them from doing so. The laws in those cases I cited were on the wrong side of history, just like this law would be if it were passed. I want to expand on this theme that enacting laws that target minorities is un-American. Laws that have targeted minorities have not withstood the test of time because our understandings of freedom changes over generations. Think about categorizing today every woman or every brown or black-skinned person as property instead of people with equal rights as white people or as men. Nowadays, we would never, ever enact laws that exclude women from owning real estate, that exclude Black people from taking out mortgages, that exclude Asian Americans from voting. Our changed understandings of freedom over generations would not allow that. And as a backstop, if laws of that type were passed, they would not pass constitutional muster. That is the same for these laws, such as 1312, targeting the LGBTQ+ community. As the United States Supreme Court wrote in Obergefell v. Hodges, changed understandings are characteristic of a nation where new dimensions of freedom become apparent to new generations. We know from our history that laws targeting minorities, like gay and transgender people, do not pass constitutional muster. We also know that changed understandings are characteristic of our nation, where new dimensions of freedom become apparent. Please, I urge you on behalf of our family and all of the LGBTQ+ community in our great state of New Hampshire, to ITL 1312. Thank you.
Thank you very much. Are there questions from the committee? Representative Lekis?
You have me confused, but thank you for taking my question. I'm reading this just as having to give notice, and then if a parent objects to particular material, you're doing a substitute, but that's a parent and a particular child and particular material. So I'm not sure how what this is doing is what you were talking about as far as limiting curriculum in general, et cetera, and how it goes specifically against LGBTQ since it talks about human sexuality, human sexual education, et cetera, which I believe involves all humans.
Thank you, Representative Lekis. I appreciate your question. There's two levels of answer to that. First is the philosophical reasoning behind writing sexual identity and gender identity into this law, which is an unfounded belief that these topics are dangerous, bad, unsafe, etc. That sends a signal to the LGBTQ+ community and the rest of the community that is unwarranted, unhealthy, unsafe for that community. It's wrong. The second thing is the notions of impracticality that the ACLU testified about. Teachers are exceedingly busy. Teachers are not just teachers anymore. Teachers are guidance counselors, psychologists, safety managers. They do all sorts of things. They are sometimes lesson planning from day to day to day. They may not know 14 days in advance exactly what they're going to be teaching. Sometimes they need to teach in response to current events. What will likely happen is that teachers will avoid gender identity and sexual orientation topics 100% because of inability to comply or confusion and fear about what is and is not allowed.
Thank you.
Representative Cordelli?
Oh, thank you. Aren't you trying to ascribe motives for this legislation to the sponsors of the bill based on your own viewpoint?
Yes, I am, but I think it's a fair ascription.
Further discussion or questions from the committee? Not seeing. Thank you very much.
Thank you.
Like to make Iris Trammell?
My name is Iris Trammell. I'm an 8th grader and a trans girl from Pembroke.
Can you move the red down towards you? Thank you.
Hear me better now?
Yes.
Thank you.
Okay. Want me to restart?
Go ahead.
Okay. My name is Iris Trammell. I'm an 8th grader and a trans girl from Pembroke. This is who I am, and nothing can change who I really am. I've lived in New Hampshire my whole life and want to be able to stay here. If these bills are passed, my family and I might not be able to stay in New Hampshire. Please vote no to House Bills 1312. I'm not going to repeat my personal story because I shared that with you last week and it's in my written testimony I'm giving you. For HB 1312, what does this mean for me? I think teachers would be busy and would probably just skip any teaching that involved LGBTQ plus issues. That would leave me and the rest of the LGBTQ plus student body completely left out and isolated from our entire education. Even worse than the other bill, this would mean no representation of LGBTQ plus anywhere in my education. Part of my identity would be ignored, thrown away. In fact, all of these proposed laws targeting me and the rest of the LGBTQ plus community have been like torture, and I wish you would stop. I would like it if you kept protecting LGBTQ plus rights, including mine. Thank you for your time.
Thank you very much, Iris. Are there questions from the committee? Not seeing any. Thank you very much. Pardon me? That was it. That was it. With that, I have no more cards in this bill, so we're going to close. Pardon me?
Possible people request from DOE, get a copy of the 2017 technical advisory.
We can do that. Yeah, thank you. So we're closing the hearing on this bill 1312. Yeah, really.
Thank you.
Frank, just put out the new TA. Why is it part of the justice? I mean, this is nuts. Yeah. And if you want to know this. It's cross. If you want to know the entire thing.
So Iris,
Right.
it appears in the purchase flurry.
Yeah, yeah, so this book, see it right there. Yeah, but if you find this. Yeah. I mean, it's not. Well, no, I mean, there's a lot of stuff. But. How do we think this mistake will?
Yes.
I think of my.
We're now going to go ahead with the next bill on today's docket for hearing. It is HB 1356. This is relative to the use of children's names and pronouns by public school employees. And Representative Willett? And for the public, due to the number of cards we're getting here, the prime sponsor has the ability to, talk as long as they want. Please don't go much more than 10 minutes though. And the others are going to be all 3-minute lengths. So we will cut you off at the end of 3 minutes. Representative, welcome.
Thank you, Mr. Chairman. Thank you, committee members. I will be much less than 10 minutes. We call this HB 1356 the Given Name Act. A child's name is one of the very first parenting choices parents make. Until very recently, there was no question about who gets to decide this fundamental piece of the child's identity. But activists in school are allowing teachers to switch a child's name and pronouns without the parents' knowledge or consent. The hijacking of names rights is more widespread than you might think. In Michigan, a State Department of Education official encouraged educators to use the student's chosen name and pronouns without notifying the parents, as did schools in Indiana, Ohio, Virginia, Maryland, and even in Ludlow, Massachusetts. Like these, parents may have no idea that their child is questioning his or her gender identity. This robs parents' opportunity to support their child or to address what might be causing the child's gender discomfort. The Given Name Act would restore control over a child's name to the parents, where it rightfully belongs. This bill would require schools to obtain parents' written consent before referring to a student by a name other than his or her birth name, or pronouns other than those matching the child's biological. The Act protects free speech as is defined by the Constitution and the Supreme Court. In instances where the parents agree to let a child use a new name and pronouns, it protects school employees from being forced to use new identifiers where doing so would violate an employee's religious beliefs. But it recognizes that, under Garcetti versus Cabellos, a teacher has no constitutional right to use a child's chosen name and pronouns against the parent's wishes. In that case, the Supreme Court ruled that speech used in official capacity as a government employee is not protected by the First Amendment. Social transition is a step not to be taken lightly, and certainly not to be taken without parental consent. Dr. Hilary Cass, the former president of the Royal College of Pediatrics and Child Health Care, said it best when she described social transition as an active intervention with potentially serious. As with any intervention in the life of a child, parents have a right to know about it and accept or refuse intervention as they see best. The only issue with the bill may be a current nickname the child has attached to them. There is an easy solution here. Ask parents for any approved nicknames on the forms they fill out at the start of the school year. If Robert wants to go by Bobby, his parents would not object. But if Robert wants to go by Rhonda, the permission slip he brings home from school could be the first indication his parents have he is feeling uncomfortable about his gender. Thank you.
Thank you very much. Are there questions from the committee? Representative Tanner?
Thank you. I taught and coached sports, and oftentimes we have nicknames for kids like Flash. Sometimes we call them by their last name, like Tanner, come over here. Doesn't this bill say that you can't do that?
This bill says that any name other than their birth name, you would have to have permission from the parent to do so.
So follow up on that?
Yes.
So, if I was coaching, I'd have to go to the parent and say, you know, the kids have found a nickname for Judy and it's Flash. And I'd have to do that rather than just be normal and react to that like I would in normal situations. That's what you're asking me to do as a teacher.
As a coach, yes.
Right.
Representative Woodcock.
Thank you, Chairman Ladd. Good morning, Representative.
Good morning.
I have two questions. One, just a clarification, if I may, and then a question. I'm looking on the bill in line 18 under employer contractor shall not. When you're talking about derivative zero, what does that mean?
I don't have it right in front of me. If you could expound a little bit.
It says a contractor employer shall not use a name or address to refer a student that does not match the name list on the student's birth certificate or derivatives thereof.
I'm not sure, and I apologize for that.
That's okay. Mr. Chairman Ladd may just do the second part.
Yes, sure.
Thank you. But I do have a question on line 25, 6, and 7, part 3. And it talks about an employer contractor not required to address a youngster because of their religious or moral conviction. And what's really difficult for me is we've been hearing over and over and over again, teachers cannot use their position. They cannot provide their opinions on things. They can't do this. They can't do that. And now all of a sudden we're saying, but a teacher or an employer can make the choice. I choose not to do that. Because on my Okay, so if I choose not to do that, isn't that direct violation of all the other bills we've been getting that says to a teacher, you can't do that? You can't show that you don't agree with that?
The Supreme Court has stated that a teacher does not have to call a student by another name than their birth name, and it's protected. The same way, because of the religious beliefs or their beliefs. But in the same way that, like I had mentioned through Garcetti and Cabello's, that teacher has no constitutional right to use a child's chosen name or pronouns without the parent's permission.
Could you just give me the citation on that so I could check that out, please?
I will get that back to you.
Thank you so much.
And again, I apologize. Representative Cole
That's
is
fine.
the prime sponsor. He's
That's fine.
away.
Fine. Thank you, Chairman Ladd.
Further questions from the committee, Representative Damon?
Thank you, Mr. Chair. Thank you for taking my question. I actually have two. So the first is clarification, if I'm understanding your introduction. So my youngest daughter, whose first name is Nadia, did not like her name when she was an elementary school student. She does in adulthood. Thank you. She went by Peanut, which was her given name from her favored grandfather, and informed at school that she would be Peanut. You, I think, please confirm if I'm correct here, are saying that the school could not accept that. They would have to get consent from the parents for the name that the child was going by and provided to them. Nothing to do with sexuality, just a nickname.
It's trying to, you're absolutely right. And it's a difficult situation. But somehow it's on the other end of the spectrum. It's got to be controlled, I believe. My daughter's nickname was Doodles. So I know exactly what you're saying. I do.
The other half?
Yes.
What does this bill do, or does it do anything, in regards to what students are calling each other? So, for example, following up on Representative Tanner's inquiry, if the students on a team are calling each other Flash or Dribbles or whatever, does the law comment on that?
It does not. It's just for staff and deals only with staff.
Thank you for your.
Further questions, Representative Myler?
Thank you for being here and thank you for taking my question. So I want to get this clear. I'm a teacher and I have a student in my class and her name is Susan Kitchen. And she chooses to go by the name of Kitch. In order for me to, and if I'm following what you're saying here, in order for me as a teacher to call Susan Kitch, because that's the nickname she wants. Before I can do that, I have to contact the parent before I can call her Kitch. Is that correct?
That is correct.
Thank you.
Further questions, Representative Alboni?
Thank you, Mr. Chair, and thank you for taking my question. I taught for a while and I was in a school district, and one of the things that you have to do at the beginning of school is send home a multitude of permission forms. And then invariably you end up having to track those down because they don't come back. So I have a student, as both Representative Damon and Myler has suggested, that want to be called a particular name that they're comfortable with, and yet that permission slip never gets returned. So that means that student has to always be referred to by the legal name.
By staff, yes.
Further questions from the committee? Representative Cornell?
Thank you. Thank you for taking my question. When you say contractor or staff, does that include cafeteria workers, bus drivers, everybody else that comes into contact with the child?
It does.
Who would have no access to any of their records or know anything about them except they see them in the cafeteria line and they say to them, oh, hi, my name is Sally, and it's not. But that's what they know them as, so they would have to get permission, say, you know, can I call your child Sally?
The staff you're talking about are school employees, and they would have to follow the same rules as every other school employee.
Thank you.
Further questions from the committee? Representative Cordiello.
Thank you, Mr. Chair. Thank you, Representative, for bringing this forward. I think you mentioned something about how this would, a positive aspect of this law would be that it would help to avoid lawsuits. And I remember hearing a case in California about the idea, you gave me a look where you didn't, but there's a positive idea of how it would avoid. There was a case in California which regarded a teacher being required to call a student by pronouns and it violated her religious beliefs. Maybe that was in regard to, so that you could avoid lawsuits like that somehow.
What the research I did, it basically said that the Supreme Court said that if it was against your religion or your religious beliefs, to call someone other than their birth name, that you didn't have to as an employee, if it was against your religious beliefs.
Okay, I just wanted some clarification. Thank you.
Thank you. Further questions from the committee? Representative Ford.
Thank you, Mr. Chair, and thank you for taking my question. Recently, schools have started doing alumni correspondence, and they include by addressing to the people by their familiar nicknames from school days. And it may well be, as an adult, you don't want to be called that name. You may have hated that name all your life. And yet, they are using from the records, thinking to be sympathetic with you, I hope, and elicit money from you. They're calling you by your hated nickname. How does this address that?
You know, when you're over the age of 18, if you can't stand up for yourself, shame on you.
In relation to that, yes, that's true. These are not students in school. Any further questions from Representative Willett? Thank you very much.
Thank you.
to that-
One more thing, Mr. Chair, if you don't mind, on a different subject. There's a bill coming up this afternoon in your committee.
Talk to me on the side about that. We're in a hearing on this one right now. So we're going to do what we did yesterday. The time limit's going to be 2 minutes, not 3 minutes, due to the cards which we have up here right now on that. So the next person will be Max Tolan.
Hi, my name is Max Toland. My pronouns are they, them. I live in Canterbury. I'm non-binary, and I'm here to testify against this bill. If HB 1356 becomes law, I wouldn't be able to learn like other kids do. My name and my pronouns are who I am. Nax is not the name on my birth certificate, but it is my name. When someone talks about you, they use your name and your pronouns. When people use the wrong name or pronoun to talk about me, or just don't use my name or pronouns at all, that's like taking away my identity. Coming out is a journey. When you come out, you talk to people. You can come out publicly, you can come out to your parents, to your friends, but no matter what, you're going to come out to someone again and again and again. You feel like you've told people who you are and what your truth is, and yet you still have to tell people and correct people and remind them. And you have to do this job of convincing people that you are real and you are valid with this simple truth. Once, before I came out at school, I was sitting at recess with my friends when another came up and used the wrong pronouns to talk about me. I sat there for the rest of my classes thinking about being misgendered, not about whatever was being taught in class. I didn't get enough sleep that night. I was focused on how I was known as the wrong person. Last year in math class, my teacher was handing out test results and said to me, "Here you go, here's your test." Before turning to the rest of the class to say they did a great job, they were the only one who got this problem right. I felt seen and like I was part of the community. I felt whole and acknowledged in a good sense when my pronoun was used casually and correctly. HB 1356 is a problem even in the most ideal circumstances where my parents write the note identifying my name and my gender. There are still teachers who are going to look at me, look at the note, and because they don't believe in trans rights, because they don't believe that who I am is real, they will still use the wrong name and the wrong pronouns to talk to and about me. they will take away my identity. I think that whether that happens will depend on the school and who teachers are. What scares me is that there is no way to see which teachers are going to be welcoming and which aren't. If HB 1356 becomes the law, there is no way to ensure that students will be able to learn in a safe environment with teachers who accept them as they are. Please vote ITL HB 1356 to allow me to learn as I am.
Max, very good timing. 2 minutes is right up. Any questions? Yes, Representative Tanner.
Yes, thank you for your excellent testimony. That was great. Do you feel that if you're misgendered or addressed in a misgendered way, it makes you more a target for harassment and bullying?
It can, especially, it really depends on who the students are, who's listening to it. But especially if the faculty use the wrong name or pronouns, these students who would perhaps otherwise not have, would definitely feel much more like it would be all right to misgender me and use the wrong name and pronouns. Because if the staff are doing it, shouldn't everyone be able to do it?
Further questions from the committee, Representative Woodcock.
Thank you, Chairman Ladd. Good morning, Max. Can you just tell me how old you are?
12 going on 13.
Great job. Well done. Thank you.
Are there further questions from the committee? Not seeing it. Thank you very much for coming today. Jonah Sutton Morse. Good morning.
Good morning. Thank you, Mr. Chairman, members of the committee. My name is Jonah Sutton Morse. I live in Canterbury. I am the proud parent of that trans non-binary child. I'm a member of the Concord Monthly Meeting and New England Yearly Meeting of the Religious Society of Friends, the Quakers. I'm here to oppose this bill. HB 1356 dictates that even when I, the parent, affirm my child's identity, teachers and staff with religious or moral convictions can disregard my parental wishes and the identity of my child. That exception is immoral and unfairly discriminates against me and my child. It also perpetuates the false notion that religious convictions oppose inclusion and love. Following the biblical injunction to let your yes be yes and your no be no, Quakers do not swear oaths. But when I say that I am clear to affirm this testimony to the committee should understand that I am stating my religious and moral convictions. Trans men are men. Trans women are women. Trans non-binary people exist, and their gender identity is real and valid. This is an incomplete catalog of the varieties of gender identity in the world. Biological sex assigned at birth is at times a useful medical indicator, but it is not a more true and accurate marker of identity than a person's own lived experiences. I'm not a public school teacher or staff member, but if I were, HB 1356 would require me to violate those religious and moral convictions if I had a trans student whose parents didn't affirm their identity in writing. There's no space in this law for my religious or moral convictions when I parent my child. But there is space for those who want to use religion to disregard my wishes as a parent and my child's identity. HB 1356 is unethical, immoral, and should not be the law of this state.
Thank you, Jonah.
Vote ITL.
Are there questions from the committee? Thank you very much for coming today.
Thank you.
Ty
Thompson.
Cursive writing here.
I'm old. We had to learn it.
Thank you.
My name is Ty Thompson. I live in Nottingham, New Hampshire. I'm a transgender, non-binary person. My pronouns are they, them. It took me a long time to be able to say that in the world with confidence and conviction. And I'm so proud of young people today who are able to step into the space of knowing and owning themselves in public ways. We need to support that. This law, as we've heard with such eloquent testimony already, is unethical and unjust. Ideally, family spaces are supportive and allow young people to blossom into themselves in ways that are safe, encouraging, and helpful. Unfortunately, this is not always true. Sometimes families have their own learning curve. My family had their own learning curve. They are loving and well-meaning people. I needed the opportunity to choose where and when to have those conversations with them. At the same time, I needed community. For young people, schools are community. Being able to explore aspects of self with the same freedom and celebrate aspects of self with the same freedom as everybody else in the school who may be self-identifying with athletic qualities, scholastic strengths that incur the same nicknames or self-identification of choices of names and the ways that they are called in the world. This law really just singles out that a trans identity is unacceptable. You are the only ones that cannot do that. Young people are required to emerge in the world with increasing agency, self-direction, and responsibility. We need to affirm that by being able to support the choices that they make in schools and in the communities. That's all I have.
Thank you very much. Are there questions from the committee? Thank you again. Gaz Bissonnette?
Thank you, Mr. Chairman, members.
Good morning again.
Good morning again. Thank you, Mr. Chairman, members of the committee. Gilles Bissonnette with the ACLU of New Hampshire. I know I have very limited time, so I'll try to keep this brief. I know there are many speakers behind me who I think, frankly, have more powerful stories about why this bill is problematic. And for those reasons, for the reasons that I'm going to go through, we oppose this bill. When the names and pronouns students wish to use are respected, it enhances that student's experience and it cultivates a positive school environment. I think in schools, let's just remember like what schools are at the end of the day. They are places where students ought to be able to figure out who they are. And I think, frankly, without formalistic and rigid rules from a state government regarding names and pronouns. Every student is engaged in school. Every one of us, probably, when we were in high school, even younger, were engaging in identity exploration. We were sometimes communicating that identity, intimate parts and concepts of who we are to friends, maybe even a trusted school teacher. And I think it's so critical to understand that that's just what schools are, and respecting that that aspect of one's education. And frankly, I think this bill would undermine that aspect of the school environment. Under this bill, public school employees or contractors will be barred from using a name or pronoun to refer or address a student that doesn't align with that student's birth certificate. And the result will be that schools will no longer become that space. Many students need to prepare to have important conversations about their identity at home. And I think that's going to hinder the ability of these students to safely seek to be identified by their preferred names and pronouns. That is, I think, just using the right pronouns is like the bare minimum of human decency, right? That I think we could provide for these students. So stripping that away, I can't articulate enough the harm that creates to, a group of students where, like, let's be real, it's already pretty hard, right?
Your time is up.
The last point I will make, there's a whole host of legal concerns. Please read my testimony, but I do want to just get at the impracticality, the derivatives language. I don't know what that means. Also, this bill covers just communications as well. It's very expansive and also includes contractors, which I think is also problematic for all the reasons that were conveyed in testimony. So I think for all of those reasons, we would ask that this committee ITL this bill.
Thank you very much. Are there questions from the committee? Thank you very much.
Thank you, Mr. Chairman.
Linz Jackhouse?
Good morning, members of the committee. I will be reading testimony on behalf of Michelle Sealy-Foisey, who couldn't be here today. Thank you, Chair Ladd and members of the committee. My name is Michelle Sealy-Foisey, and I am a mother of 6 and a physical therapist from Temple. I am writing in opposition to this bill. Having given birth to 4 of my children and being blessed with the other 2 coming into my life through marriage, I've always been a strong advocate for all of my children. From the moment they entered my world, I have never felt that they belong to me. They are not my possessions. I have always called them my little people, as they are just that, their own person. I believe that they have the same rights as we adults have, and as parents, we are here to see that they are allowed those rights. I did not become a parent to control their path and future. I am here as their mother only to love them unconditionally and care for them with no bounds. My now 17-year-old has been experiencing gender dysphoria along with severe depression over the past few years. It has been several years that they have been experiencing the feeling of being lost in their own body, but I did not hear of this until their 16th year. Last year, my teen was in such a dark place that they tried to take their own life while feeling incredibly isolated and alone in their thoughts. Today, they have the full support of their parents, their family, and their friends as they begin their own journey to living in a body that feels more like their home. In October, they asked all of us to begin to use they, them pronouns and continue to support them in this journey. I cannot help but think how they would have felt if they had reached out to someone sooner. Up until last January, they attended public school. If my teen had chosen to speak to one of their teachers and ask them to use they, them pronouns before they were ready to ask me to use new pronouns, I can say with confidence that I would have been incredibly thankful for the support of their teachers. Being able to share who you are with the world is incredibly important to all human beings. Feeling accepted and uplifted by others when sharing who we are is one of the healthiest experiences we can have as people. Having the support accessible in any and every way is essential to allowing all people to thrive in their own lives. As a parent, I do not feel threatened or negated by others supporting my child. I am grateful every day that each of them feel the love that others may have for them, and I wish this for all the little people in the Granite State. Sharing with their teachers and their school community what pronouns they wish to use in school will only allow them to feel this love and will do no harm.
You have gone beyond the 2 minutes.
Thank you.
Thank you very much. Are there questions from the committee? Thank you very much. Pardon me?
Michelle, who I read this, it will send.
She's reading it for Michelle.
Thank you.
Yes. Thank you very much. Sam Hawkins.
Good morning, Chairman Ladd, members of the committee. Thank you for the opportunity to testify today. For the record, my name is Sam Hawkins. I'm the Public Policy Assistant at NAMI New Hampshire, the National Alliance on Mental Illness. NAMI New Hampshire is a nonprofit grassroots organization whose mission is to improve the lives of all people impacted by mental illness and suicide. On behalf of NAMI New Hampshire, I'm here today to speak in opposition to House Bill 1356. NAMI New Hampshire believes that acceptance and support within one's community is a key factor of mental wellness and should be a goal across all aspects of everyday life for youth and young adults. And as such, I would ask that you give a lot of weight to the lived experience of the folks who shared before me and the folks who will share after me. And the importance of maintaining affirming environments for transgender youth cannot be overstated. According to the Trevor Project, in 2023, roughly half of transgender and non-binary young people found their school to be gender affirming, and those who did reported lower rates of attempting suicide. For transgender and non-binary youth specifically, respect for their chosen name and pronouns is a critical aspect of this support. According to a study in the Journal of Adolescent Health, compared with youth who could not use their chosen name, young people who could use their name across all areas of their life experienced 71% fewer symptoms of severe depression, a 34% decrease in reported thoughts of suicide, and a 65% decrease in suicidal attempts. HB 1356 jeopardizes school as an affirming environment for transgender and non-binary youth, putting their mental health and safety at risk. For these reasons, we urge the committee to vote ITL for HB 1356.
Thank you very much. Are there questions from the committee? Not seeing. Thank you.
Thank you.
I'd like to call Sarah Smith. Good morning.
Good morning. My name is Sarah Smith. Although I was known as Sally for 21 years without any question from anyone. I'm a retired public school teacher. A good portion of our training was in developing respect for children's differences. I spent many years, among other activities, supervising children on the playground. If a child on the playground reported that another child had misgendered them, I would consider that bullying of the most serious sort. If an adult in the school employee had done that, I would have considered an abusive treatment and reported them for it. For a person in power, and all adults in school fall into this category, to treat a vulnerable child in that manner is no different from using a racially derogative term. No matter your religious beliefs, no one would consider that acceptable. That is hate speech. Misgendering a child is also hate speech. If someone did that to my child, I would file a civil rights complaint. A teacher is not supposed to be using hate speech, including using incorrect pronouns or anything derogatory to a protected class of students. Remember the clerk in Kentucky who refused a marriage license to a gay couple in Kentucky? In March 2022, the federal district court Judge Bunning ruled that Davis had violated the rights of two couples and that her religious beliefs did not justify her refusal to issue marriage licenses to same-sex couples. She was fined $260,000. For these reasons, I oppose this bill. It is inexpedient to legislate in the most serious sense. Happy to take questions. That's all I have to say.
Are there questions from the committee? Not seeing it. Thank you.
Thank you.
Call Emma Savigny.
Good morning, Chairperson Ladd and members of the committee. Thank you for hearing my testimony today. My name is Emma Savini. I'm the Children's Behavioral Health Policy Coordinator at New Futures. New Futures is a nonprofit, nonpartisan organization that solves problems through policy change. New Futures is here in opposition to House Bill 1356 because young people have the best mental health outcomes when they feel supported in their communities and schools. House Bill 1356 is in direct opposition to this goal. We all envision a New Hampshire in which children feel welcome and supported in their communities, using their gender, their names and pronouns that they that align with their gender identity is a simple and safe way of affirming our children and making them feel safe and welcome. House Bill 1356 would limit a young person's ability to use those pronouns and names that align with their gender identities without parents' written permission. Even in the best families where children are supported and loved, many children feel safe exploring their gender identities in schools prior to coming to their parents. And in those worst case scenarios, the very, very slim worst case scenarios where children are in non-supported families, it's even more important for children to be able to explore their gender identities through the use of names and pronouns in schools. We know that when young people are not supported in families and face familial rejection, they are 8.4 times more likely to report having attempted suicide, 5.9 times more likely to report high levels of depression, 3.4 times more likely to use illegal drugs, and other serious consequences when compared to their other LGBTQ plus peers who reported no to low levels of family rejection. But we know that when children have at least one trusted adult outside of their families, typically a teacher or maybe a coach, somebody who is an adult that they can turn to for support, we know that their mental health is on par with their peers. And we know that those that one trusted adult is a mitigating factor to childhood trauma or an adverse childhood experience. With that being said, I would ask this committee to ITL this bill, and I'm happy to take any questions.
Thank you very much, Emma. Are there any questions from the committee? Thank you.
Thank you.
I'd like to call Amy Manzelli.
Thank you, Chairman Ladd, members of the committee. Nice to see you again after so long. My name is Amy Manzelli, and I'm here on behalf of myself and my husband, Chad Trammell. We are residents of Pembroke, New Hampshire, and we are here to urge the committee to ITL House Bill 1356. Again, I'm not going to repeat the story of our personal family history with our 14-year-old transgender daughter, Iris, having come out when she was 6 years old. And I'm not going to go through the litany of cases from the United States Supreme Court overturning laws that targeted minorities. Instead, I want to give you my final comments on how un-American it is to target minorities and what happens at home when laws like this are proposed. In our family, we sit down together every single morning before school, every morning on the weekend, and almost every night to have breakfast and supper together. We talk about our days, we talk about our lives, and questions come up. And I want to share with you some of the questions that have come up. Why do people think Iris is too dangerous to use the girls' bathroom? What do people think Iris will do to them in the bathroom? Why can't Iris play on the girls' team anymore? What do you mean that people think Iris is not safe? Why do people think Iris is dangerous to other players on sports teams? Didn't a judge order that Iris is female and that Iris is Iris's name? Wait a minute. I thought it was not okay to talk about other people's private parts. Why do people care about other people's private parts? You mean a teacher might have to be talking about Iris's private parts and other LGBTQ people's private parts? And lastly, and most importantly, I thought I had civil rights at school. As a parent, it has become nearly impossible to field these questions while also maintaining a positive attitude and a positive morale in our home. And it will become absolutely impossible if this and the other litany of laws targeting the LGBTQ community are passed. Please, on behalf of our family, I am begging this committee to ITL this bill and the other LGBTQ laws. They are wrongfully targeting a minority that does not deserve to be targeted. Thank you so much for this committee's attention and time on all of these bills.
Thank you very much, Amy. Are there any questions from the committee? Thank you very much.
Thank you.
Call up Iris Trummel. Good morning again.
Yep. My name is Iris Trammell. I'm an 8th grader and a trans girl from Pembroke. This is who I am, and nothing can change who I really am. I live in New Hampshire. I've lived in New Hampshire my whole life, and I want to be able to stay here. If these bills are passed, my family and I might not be able to stay in New Hampshire. Please vote no on House Bill 1356. I'm not going to repeat my personal story because I shared that with you last week, and it's in my written testimony I'm giving you. For HB 1356, this could mean teachers could use my dead name. I would not want to go to school anymore if that happened. I would never want to learn from an educator who called me by my dead name. If any teacher did that, I fear students would start to use my dead name again also. That would be like torture for me. In fact, all these all these proposed laws targeting me and the rest of the LGBTQ community have been like torture, and I wish you would stop. I would like it if you keep protecting LGBTQ plus rights, including mine. Thank you for your time.
Thank you, Iris. Are there questions from the Representative Damon?
Thank you, Mr. Chair. Iris, thank you once again for being here and helping us appreciate who you really are. Could you tell me what you would be doing if you didn't need to be here, finding a way to help you be safe?
In school, probably.
Follow up?
Yes.
And would you prefer that?
To be honest, kind of, yeah.
Great answer. Thank you.
Especially if it's recess, right?
Don't have recess in
Whatever.
8th grade.
Are there any further questions from the committee? Thank you very much, Iris. David Trumbull? We're going to ask the same question of David here. What would you be doing if... From where? Thank you very much.
Thank you, Mr. Chairman, committee members. My name is David Trumbull. I'm from the town of Ware. I oppose this bill. First of all, I think the most important thing is that when we use somebody's pronouns that they want, we are showing them respect. And when a school has a policy that follows that same guideline, the school is showing respect. And when society has rules that implement that, society is showing respect. And this bill would destroy that respect for LGBTQ children. It is very clear that the policies that you make will affect the mental health and well-being of transgender children. You've heard statistics. I won't read any more for you, but it is worth noting that 25% of LGBTQ students use pronouns that are outside the binary. That would be he, she, and or they them only, or neopronouns. And most children have friends who use gender neutral pronouns. So this bill would affect a large number of people, not just the general concept of rights. We have to balance rights. Sure, parents have fundamental rights to raise their children, but there is not a single Supreme Court case that stands for the proposition that parents can use the school as a surveillance tool to find out if their children have different pronouns. There is no Supreme Court case that would carry the fundamental right of parents to that extreme. Whose life are we talking about here? The parent's life or the child's life? In the end, the child is the one who goes to school every day, who grows up and has a future. And we should be looking at the children and their future well-being as the guiding interest in our state making this decision. Thank you very much.
Thank you very much. Are there questions from the committee? Thank you very much.
You're welcome.
Maya Engelbert.
Hello, my name is Mia Engelbert. I live in Manchester, New Hampshire, and I use she, it pronouns. As you might have guessed from those pronouns, I am a transgender woman, and if my school outed me to my parents, I would have been absolutely horrified. I believe that all my transgender siblings deserve control over their own personal stories, their own bodies, and anything else about them. So, and if they're outed at the wrong time by the wrong person, the results could be disastrous. Not everybody has a supportive family. Not everybody has a supportive peer group. Not everybody has supportive teachers. They could be bullied, harassed, or even worse. I simply believe that all my transgender siblings deserve to be respected. They deserve to be addressed by the names and pronouns they choose. And I don't think I have anything else to add. So thank you for letting me speak.
Thank you, Maya. Are there questions from the committee? No, thank you. Have a good afternoon.
You too.
Or morning. I'd like to invite Beth Scare.
Thanks. I'm Beth Scare. I'm a grandmother from Nashua, and I'm here in support of HB 1356. This is a bill about parents' rights. Parents of trans-identified kids are suffering greatly. I communicate with them frequently. Their kids have come under the influence of teachers, peers, and social media influencers. And parents know what is best for their kids, and they know when a transgender identity is not right for their kids. No one knows their kids better than parents. School staff are not going to be there to pick up the pieces when their child realizes in their early 20s that the medical interventions they followed, cross-sex hormones and having healthy body parts removed, was all a terrible mistake. And we are hearing more and more from more and more young people that are coming to grips with this. Please protect parents and kids and vote ought to pass on HB 1356.
Thank you. Are there questions from the committee? Thank you very much. Brennan? Is that an N right there?
Brennan.
Okay.
Brennan.
I apologize. I had a hard time reading the last name.
Would you believe I used to teach kindergarten and had to write on the board?
All you need to learn is learn in kindergarten.
Actually, I have taught kindergarten, first grade, and 7 through 12, mostly high school. I'm from Ware. I got many awards for my teaching, including New Hampshire Teacher of the Year. I prided myself on paying attention to my students and helping them when they needed. Not grooming them, just listening to them. So I have a story. When I was at a theater festival, after I retired, I was one of the adjudicators and I was handing out the prizes. We had a person from another school whose parents had vehemently insisted that in the program, their dead name, which is what a trans person calls the name they no longer use, be put in the program. This child received the highest award for acting, and it was my privilege to give it to them. And when I called them up, I called them by their true name, not their dead name. And when they thanked me, they threw their arms around me and said, "Thank you so much." And I said, "You deserve it. You were the best actor here." And they said, "No, you used my name. What would you have done?"
Thank you very
Thank
much.
you.
Thank you very much. Are there questions from the committee? Thank you very much. Oh, we represent Tanner.
Thank you very much, and congratulations on being Teacher of the Year. It's a tough thing to make, so we have one that usually is on our committee as well.
I know him.
So my question is, what do you think it does to a student in school to be misgendered? What do you see as some of the side effects that happen?
I can't imagine. I have transgender friends. I've met transgender children. The kids that I know that grew up that are transgender were not out in school. I stopped teaching in public school a few years ago, but I cannot imagine because I've seen bullying. I was very often, I was the theater teacher. So I was very often, I also taught algebra. I was very often the teacher that kids would come to say, "Mrs. Brennan, I'm gay, and I'm trying to figure out how to tell my parents." And I would listen. I didn't feel like I groomed or anything like that. But I do know what bullying does. And I remember one kid, I don't know if he was gay, but he was being bullied by another kid. They were using the F word. And I spoke to that kid. He was very belligerent. He wasn't one of my students. I called his mother, and his mother came in, and she said, "In our house, in our church, there are no gays. My son is free to use that word against those kids in the school." Of course, then we had to get other people involved and say, do it at home. You can't do it here. But I just know how hurt kids are when they're bullied. And to me, this is the ultimate in bullying.
Thank you. Further questions from the committee? Thank you very much for coming today. And with that, we're going to close this hearing. And for the committee, we're going to take a short break for people to get up and stretch a little bit. And we'll come back and start this one up at 11:15.
We're still at plug 79 tomorrow, right?
Yeah, I understand. Yes. And what's the judge say? Put your butt back in the chair. Thank you. Thank you very much. Thank you. Okay, we're going to call this hearing process back to order here, please. I see we have state reps Ford and Perez. Who's going to introduce the bill? Welcome. You couldn't pass it off to your fellow rep there, huh?
Thank you, Mr. Chairman. I'm the prime sponsor, and I'll be filling out a pink card.
Oh, okay, okay.
My apologies.
That's okay. We'll get it.
Well, thank you, Mr. Chairman, and members of the committee for considering my testimony with the intent to repeal the law known as the right to freedom from discrimination in public workplaces and in education. So thank you so much for taking my testimony. I am State Representative Peter Petrino from Hillsborough 43, the town of Milford. So this is a law that frankly should not be on the books. I do believe that it is an insult to public school teachers and it impugns their professionalism. Now, I was a high school social studies teacher for 40 years, both in private and public schools, and I served as department head, and I chaired my district's K through 12 social studies curriculum revision. And in all that time, I never, ever heard of critical race theory or divisive concepts. So I had to do a little digging. And I was surprised to learn that this was not a New Hampshire issue, but rather a national effort on the part of certain political action groups who believe that public schools are indoctrinating children with certain beliefs about race and gender and other so-called divisive concepts. As I see it, the law has little to do with real discrimination, but everything to do with silencing teachers' voices on topics that some just don't want discussed. Now, the bottom line is this: racism is real. It is ugly and it's insidious, and it has no place in New Hampshire or anywhere in America. Now, we know that the only way to cure a disease is to confront it. Racism and all forms of hatred and discrimination is a social disease. And the only way to stamp it out, just like any disease, is to confront it head on. And you can't do that if you cannot talk about it. Now, look, it's true that the law does allow for the teaching of history, slavery, the Civil War, the Civil Rights Movement, and so forth. It can be taught. But teaching history is more than just knowing about the who, the what, the where, and the when. It is also understanding the why and the how. Students need to know how to conduct unbiased research. They need to be able to synthesize and evaluate, analyze the information that they've gathered in order to form well-reasoned evaluations about the world they live in. And this cannot happen without honest and open discussions when learning about these topics. Now, it's one thing to tell students that the civil rights movement happened in the 1960s. It's another thing to freely discuss why it occurred in the first place. So when students are watching a video on the civil rights movement and they see the police dogs attacking and the fire hoses spraying African Americans who are protesting for equal rights, and a student asks, why were so many white people racist back then? Does racism like this still occur today? Can an honest discussion ensue, or does the teacher have to say, the law doesn't allow us to attribute motivation for such behavior? Now, this is where the disconnect is. This is why teachers are uncertain as to what they can and cannot say in the classroom. And more so, there is fear of retribution should they allow such conversations to take place. Let's take a look specifically at the law. I fully agree with many of the law's main principles. But were teachers really telling students that they were superior to others, or that others should be discriminated against, or that they should be treated less than equal? Those are three provisions in the law. Was such discriminatory classroom instruction really happening in schools that this law was needed to prohibit? Of course not. But those provisions make the law sound perfectly reasonable and anti-discriminatory. The real concern is the one provision which prohibits identifying an individual or a group as inherently racist, sexist, or oppressive, whether consciously or unconsciously by virtue of their various protected classifications. Now, within that list of all those classifications, I bring to your attention the word creed, by virtue of one's creed. A creed is a set of beliefs or aims which guide someone's actions. And the fact of the matter is that there are beliefs in this country which are racist, oppressive to women, discriminatory to the LGBTQ plus community, anti-Semitic, Islamophobic, and more. Creeds are not just formal statements of beliefs, but they're also manifested by words and actions, such as by those of the numerous hate groups identified by the state's Attorney General's office. Does this law give cover to those hate groups, or can classroom discussions identify them for what they are? While not everyone who agrees with this law is racist, it is safe to say that every racist supports this law. Some will say that the teachers are wrong, that they can still teach as they always have, and others will say the racists are wrong, that this law is meant to prevent discrimination. But what really is wrong is this law. It's a detriment to meaningful education, and it must be overturned. So we ask for your consideration to recommend to pass. Thank you so much, and I'm happy to take any questions.
Thank you very much, Representative. Representative Cordiello?
Thank you, Mr. Chair, and thank you for taking my question. My concern as I read this very short law, which seeks to repeal what is on the books, is I won't read every word. It's sort of in the middle there, starting at line 4. Nothing in Title 15 shall be construed as barring any school employee, kind of goes on, from engaging in any form of instruction. This is the phrase that concerns me a bit, any form of instruction. It seems to me that the current law provides what I think a lot of people would identify as guardrails, because I won't go into details of anecdotal evidence, but a number of stories that I've read about children come home, they go to their parents, they're very upset because they feel like they after a class that they feel that they're, oh, mommy, am I a racist? Am I, oppressor? Things like this. So if a teacher employs a form of instruction that makes a child feel that way, is that okay? Because you're saying any form of instruction. And I'm concerned about that lack of guardrails.
Well, as I had mentioned earlier, there are a number of provisions in this law that sound perfectly reasonable. You have to ask yourself, okay, were teachers really instructing students that they are superior to others? I don't know of any classroom teacher that has ever done that. Or for that matter, that they should discriminate against, and this is actually in the law, okay, that you're not supposed to go and teach that somebody should be discriminated against or that somebody should be treated less than equal. The only thing that's in this law that I and many disagree with is the provision that says that we can't address the issue if whether or not certain individuals and groups are inherently racist. And guess what? There are individuals and groups who are inherently racist. We see it all the time. Many of our colleagues have received emails and letters from racists who have called us awful names because of our position regarding equality for all people. I don't know of any public school teacher who has ever instructed their students to be discriminatory or racist.
Thank you. Are there further questions? Representative Damon?
Thank you, Mr. Chair. Thank you for bringing this bill forward and taking my question. And I guess I should just clarify, you are not currently teaching, is that right?
I'm retired after 40 years, and that's what afforded me the opportunity to run for state representative.
Thank you for your service. So my question is, if you were teaching today, would you feel a need to teach differently than the way that you did before you retired?
Absolutely.
And could you give us a couple of examples, please?
Well, again, who, what, where, when, the basic facts can be taught. But when you get to the why and the how, if you know Bloom's taxonomy, you go from the basic knowledge and you have to work yourself up to a place where you can begin to have honest and open discussions, particularly on the high school level where I taught for many years. It is really about students being able to grapple with all kinds of information and to synthesize it, analyze it, and then form independent thinking. There's a real big difference between education and indoctrination. It's a fine line, but good teaching is about education, not indoctrination. There's a big difference between teaching and preaching. It's a fine line, but it can only happen when you go up to taxonomy and you actually start to have serious, critical thinking issues. And so, to be honest, this law prevents that kind of discussion. Can we actually talk about why racism has occurred or how we deal with it right now? Guess what, folks? Racism is real. It's real. We need to be able to talk about it. And honestly, I don't think we can, because I'm always looking over my shoulder to wonder whether or not somebody's going to misinterpret what's going on in the classroom. So.
Thank you. Thank you. Representative Belcher?
Thank you, Mr. Chair, and thank you for taking my question. You presented some analysis, a fair bit of which I tend to agree with. I think like you, I said, I think there's good provisions in the existing law. I think there's some areas that are imperfect, and you really identified the creed portion as being a major problem. I kind of tend to agree with that. However, my question to you then is why did you bring a bill to repeal the entire law instead of narrowly tailoring it to that creed provision?
Well, because I think that 3 of the 4 provisions in the law really are unnecessary, and it's an insult. You know, one of the things that I've learned since being here is if you want a chance for a bill to pass, you have to give it a very nice sounding title so that it sounds reasonable. And then you have to take your real intent and you have to bury it within a whole bunch of other stuff that sounds very reasonable. So when you read this law, it sounds pretty reasonable. You know, we should not be instructing students that they are superior to others. We should not be instructing students that they should discriminate against others. We should not be instructing students that they should treat others less than equal. Really? Seriously? Do those 3 provisions need to be in this law? Because teachers aren't teaching students that. But you put it in the law and it sounds really nice. It sounds anti-discriminatory. But wait a second, let's look at that other provision. That's the crux of it. That's really what we want. We don't want teachers to talk about issues regarding race and gender in the classroom. We cannot call out somebody who is inherently racist or groups. And you just go up to the Attorney General's office and there's a whole list of hate groups that we can identify. And so when I brought up the example of the student who asks the teacher, are some people racist today? Oh, I'm sorry. I guess you'll have to infer that on your own because we really can't talk about that. We're not allowed to attribute motivation to other people's behaviors. We don't really know if they're racist. They're acting this way, but we can't talk about it. So again, very, very quickly, most of the provisions which sound really good that you and I agree with aren't even necessary to begin with because those things aren't happening. But the one thing that you and I do agree with, that's going to go.
One follow-up.
If I may, just to follow up, because I think you clarified that the other things are issues, the idea that they're not necessary because it isn't happening, but if you're familiar with it, can you talk to the teaching of the concept of privilege based on things such as race, gender, or religion, and how that concept is actually different from teaching any sort of superiority or inferiority?
I'm not sure I do understand your question. Please restate that. I didn't hear everything you said.
Well, if you are familiar with the concept of privilege that is taught in
privilege,
schools,
okay,
can you
yes.
explain how the concept of privilege is a concept that is not fundamentally similar to the concept of supremacy or inferiority?
Well, I think with any topic, whether it's a privilege or superiority, honest, open discussion, a free exchange of ideas, because one person's concept or definition may be different from somebody else's. But again, that's the whole difference between teaching and preaching. When you put something on the table and you have an honest, open discussion, you can have a free-for-all of ideas. You don't want to define something, okay? But you want to be able to offer different perspectives and then have students take that in and make their own opinions. I mean, here we are, all of us sitting around this table with different points of view. And the point of view that we have comes from a place of reading, reflecting, thinking, conversing with one another. Rather than just be closed-minded into our own little world, we try to open up discussion and be honest with one another. And that's how you have education. The other way is to tell people. That's indoctrinating. I'm going to tell you what is right and wrong. This is what is. This is what isn't. That's indoctrination. But when you have open discussion and a free exchange of ideas and people are free to have their own thoughts, now we're talking education as opposed to indoctrination.
Thank you. Representative Lekes?
I'm going to ask you what you think of a few things that I and friends of mine actually experienced. I had a friend, she, very blonde lady, married to a very black man, 6 kids, all different colors. The palest one of the kids came home from school. I was there when this happened. Came home from school in tears because she was a racist, because she was white. And her teacher said all white people are racist. And she was very upset because did that mean she didn't love her brothers and sisters or her father just because she was paler than her siblings? She was very upset by that. And a young boy came home very unhappy because his best friend was a girl. And he was told that all men were oppressors. And he was in tears. I don't want to hurt my best friend. She's my best friend, but she's a girl, and they said that all boys are oppressors, and that means I'm going to hurt her. So are those things, and those happened before this law was passed, are those things that should have been being taught and that maybe this law might have curtailed?
Well, what I would say is that there's something wrong with that teacher. That's an individual who should not be in the classroom. And so, absolutely. But I think you can look at every single profession, whether they're police officers, whether they're Catholic priests, whether they're elected officials, where you will find individuals who violate the public trust. And in each of those instances, we deal with the individual who has perpetrated the situation, and we deal with it accordingly. And so, so there's some people who should not be in the classroom, but we don't paint everyone with the same brush. And one of the things I find most offensive as a former educator and now being a legislator and seeing some of the bills that are coming forth, it's like we're painting all educators with the same brush. We want to use that example to go and say, look at all these teachers and look what's going on in the schools. And that's not true. We have quality police officers who should not be maligned because of the inactions of others. We have very good priests. We have excellent legislators. And we should not be judging all because of the misdeeds of the few. If I was the administrator and that teacher was in my school, I would see to it that we'd be taking action against that person.
Thank you very much. we have 10 cards up here and we're running out of time. I'm already going to have to nail down those testifying to 2 minutes. We'll have to go less. Is this an imperative question, Representative Ford? Is it relevant to the bill? Yeah. Then go ahead.
Thank you for taking my question.
You're welcome,
Recently,
Representative.
all of us have discussed, there was a politician who was asked a question about the cause of the Civil War, and the answer was not satisfactory to all people in the community, each group for a different reason. When I heard it, as someone who grew up in Louisiana, a white person, and was taught that the Civil War began at a point and it was a question of states' rights to do a whole category of things, I think of the war starting at a different time than someone who says it only started when Lincoln decided to make race the issue, and then it pivoted, and that became the prevailing issue, and it carried the day. But it wasn't the start of the war. And so if I raise that question, am I a racist for saying the war started before you said it started, or before it became about your group of people or my group of people or whatever? I'm just trying to get at the historical truths. And yet the interpretation is you're a this or you're a that, because we live in that kind of society today, as does the teacher and the students. So how does that affect what you're trying to object to when what I would say we're trying to teach the truth? There were a lot of reasons for that war. A lot of people died before you think it even started. Some were white and some were black. And I grew up with people, and another rep and I talked about, if people who were reared by black people like us, people like us. We knew who ruled.
Do you have a question?
Yes, I do.
Well, get it done quickly, please.
Okay, thank you. Our question is, what's the truth and how do you teach that?
Absolutely. So first of all, history is written by those who study historiography, and they're the ones who write the textbooks. But even then, what is written is always up for further discussion and interpretation. And that is why when you teach, and you're only teaching about the who, what, where, and when, you're giving the basic facts. And maybe there is a different perspective. And that's where you come up with the whys and the hows, and you start reaching those higher order thinking skills. Quality education is about having honest and open discussions where everything is on the table, whether we agree or we disagree, but yet we're able to talk about it. And when the day is done, we can all walk away with our own points of view. You know, we all have opinions, but I like to say that opinions mean absolutely nothing if it's not based on well-reasoned research. Come with the information and present it, and then have sound arguments. Otherwise, opinions are really meaningless because, this is how I feel. Really? Why? Did you do the research? Did you look it up? You did? Let's hear it. Oh, wow, I never considered that point of view before. Thank you very much. Honest and open discussions. This law does not allow for honest and open discussions because, frankly, there are some things that are just a little too sensitive for people to talk about. This is really about education, not indoctrination. Thank you very much, committee. I appreciate it.
Thank you very much. I'd like to invite Representative Perez, and we're going to go down to the 2-minute rule for those that are coming up to testify hereafter.
First name.
Patricia.
First name. That's fine.
Good morning. My name is State Representative Maria Perez, and I represent District 43 in Milford. I'm here to testify in support of this bill. As an immigrant from El Salvador, let me tell you, I've been discriminated against by saying that I'm mestizo. I'm very proud that my mom was an indigenous person. My dad was from Spain, a white person. When my dad met my mom, she was an indigenous person who never wore shoes before she met my dad. She was walking bare feet. I have a brother who's a famous artist around the world, but people don't know that. Because people only take the time to tell me that I need to go back where I came from, that my family doesn't belong here. The people who look like me, we only here to cause troubles, and we don't give anything back to the community, or we taken away from people here. I just want to let you know that my family is biracial. My grandson is a white little boy. I love him to death, and I'm expecting another one in June. I'm proud to have a biracial family. I just want my grandkids and my grandkids to learn our history, the history of my family, the history of my dad, who was an architect. He was one of the architects for the most famous buildings in El Salvador, but people don't know that. I want the stories of families like mine to be taught. I'm not here to erase anyone. I'm not here to say, I'm better than you or you're better than me. I'm just here to tell you that I'm equal as you. And I just want my family and other kids who look like my family to have the opportunity to listen to their stories. Thank you so much.
Thank you. I'm a real technician. Thank you very much. Are there any questions for Representative Perez? Thank you very much. Representative Ford? 2 minutes. Welcome.
Good morning. Still good morning, right?
It's
Damon Ford, New Hampshire State Representative for District 40. That's Manchester's wards 1, 3, 10, 11, and 12. But more importantly, I come before you today as a parent and a community member of Manchester, New Hampshire. And I am here to support this bill, 1162. For multiple reasons, but I will keep it short because 2 minutes is not a long time. So part of the problem that I have with the current law is that it says historical. And so when I think about what's happening now, where we have conflicts in the Middle East, where we could talk historical pieces of it, but we should also be talking about the current issue at hand with these particular topics, especially in the high schools. And so what about the present and what about the future of these conversations? The current law states that it is only a larger conversation can happen when in regards to the historical nature of the issue. And so I think about conversations that we can have currently with our students. And then secondly, I want to point out that complete history is important. Hearing from the winners and losers gives us a full picture of what happened. And so a member on this committee stated that they were from a certain area and this is what they learned. Well, that's what you learned at that time. We have more information. We have more voices. We have more opinions when it comes to historical pieces, right? George Washington crossed the Delaware River, but we just heard that from the outside perspective. What did George Washington think? What did the guys who were rowing the boat, right? We need all of those perspectives to fully understand the important American history that we have in this country. And so if this law is repealed and Bill 1162 is passed, we will be able to get the complete and colorful history of America without hiding behind, well, this is what I learned and I think it's important, or we're going to stop the conversation right here. Let's keep having the conversations. And I will leave with this final note. We just had MLK Day, and I spoke in front of some students about the beloved community. And the beloved community is not the avoidance of conflict, but it is the meeting of conflict and having conversations. And so if we want to build a beloved community here in New Hampshire, we should pass HB 1162 and repeal the current law. Thank you.
Thank you very much, Representative Ford. Are you willing to take questions?
Yes.
Representative Peternell?
Thank you very much, and thank you for taking my question. This bill would repeal RSA 193:40, and I'm curious if you are familiar with 193:40 Roman numeral 2, which states, "Nothing in this section shall be construed to prohibit discussing, as part of a larger course of academic instruction, the historical existence of ideas and subjects identified in this section." Do you think that that section of the law prohibits having conversations about any of the topics in the earlier section of this law?
Did the reverse thing. I think that section is actually the part that got me the most because academic instruction, we hear, I work with high schoolers, and there are a lot of conversations that are about academics, but are not academic instruction. And so how do you have a conversation with a student who will not violate this particular piece of the law? Is really difficult. And so let's say we're talking about race and slavery, or let's talk about Reconstruction and Black businesses, and a student is talking about how their parent is trying to get a bank loan and they think it may be related to race, right? Do you say, I don't want to talk about your family trying to open up a business, student, because it's about your Black parent trying to get a loan? Or it has no academic instruction and is not historically tied to the Tulsa race riots, which were also known as the Black Wall Street, which is financial hub for Black people in Oklahoma at the time, right? So you can make these academic connections, but if you stop the conversation of where students are, right, they only have their perspective. So race to them is what they learn from their family, from their community, and from their local community. And so when they bring that into the classroom, you cannot say your lived experiences must stop at the door because we're having academic instructions in this room. And so when you do that, you prevent students from actually bringing their full selves to the classroom. And so, because there's no student that I work with who lives in the history. There's no student I work with that lived in the 1960s. So when we talk about historical, that has already been written, and there are other stories and voices that need to be heard. And you cannot relate that to real lived experience that students are having today in an academic instruction way that this bill, the current law, states it.
Thank you for your follow-up.
So do you think that if Roman numeral 2 was rewritten to incorporate some of your concerns, would that affect the way the current law is written to make it more palatable?
To be honest, I dislike this law in general, and I will state personally, the intent behind this bill is it's not great. What has been written here is parts of it, and has been mentioned multiple times from the primary sponsor and others on this committee. There are great pieces here. Yes, we love that part. But what was the intent behind the law? So let's get rid of the law completely, because we can continue to have these conversations, and the current HB 1162 gets to, let's not discriminate, let's keep the parts that really work well. And I think if the only thing is once again, we're creating legislation that hinders the ability to have conversations and have these topics discussed in an academic classroom. And so let's repeal the entire RSA for that matter.
Thank you very much. Are there further questions from the committee? Thank you very much.
Thank you.
You're welcome. Sarah Robinson?
Hello, everyone. Thank you, Mr. Chair. Thank you, committee, for the opportunity to speak. My name is Sarah Robinson. I'm the Education Justice Campaign Director for Granite State Progress, and I am here in support of HB 1162. By now, we are all aware of the effect the banned concepts law has had on our public school classrooms, and I want to speak today. What I want to speak about today is the effect this is having on my own children and their future as members of a local and ultimately global community. My daughters attend a public school that my family is very proud of. My husband and I have strong relationships with our daughters' teachers. Our girls are excited to go to school and are valued in their classroom. The dark cloud that the banned concept law has cast over our public school classrooms will not escape our experience despite our strong involvement with our children's education. When I was going to school, I was taught that states' rights were the cause of the Civil War, while the role of slavery was minimized, instead of being taught to fully examine the pivotal role racism played, its lasting legacy, and how to build a better future. I want better for my children so that they are able to treat their peers of all races, genders, and backgrounds with dignity and respect. A small group of anti-public school politicians want to fearmonger instead of examine what it looks like to talk about the past in an honest way. We can all come together to overturn this law and start working toward a better future for New Hampshire's public school kids. I want my children and their peers to be prepared for interacting with a wide range of individuals as they continue to grow on their individual paths, and to have an honest, shared understanding of the world around them. And I don't want laws like banned concepts to make teachers fear for their livelihoods when they teach our country's history or explore difficult concepts related to race, gender, ableism, and more. There is a clear and consistent attempt by certain decision makers to minimize an honest education, to sow doubt in our public schools, and defund those institutions of public good, to make it harder for certain students to see a healthy, thriving future for themselves, and ultimately to dismantle public education. The Banned Concepts Law is a part of this effort. Now that the anti-critical race theory hysteria has died down as part of the culture wars and ultimately has evolved into the anti-LGBTQ and anti-SEL rhetoric we are now seeing, it's clear that the Banned Concepts Law was one part of a larger plan.
Your time is up.
Thank you very much, Mr. Chair. I'm happy to take questions.
Do you
if
have
there
a
are any.
written testimony?
I will submit them electronically. Yep.
Are there any questions from the committee? Yes, Representative Tanner?
Thank you.
Yeah.
And thank you for taking my question. Do you ever think that your daughter comes home from public school and maybe says to you something like, you know, I was called a racist today, or your son said, you know, I was called a sexist, so that means I'm going to hurt my girlfriend, that maybe that was a misunderstanding with what was going on in school? Have you ever had any situation where your children have misunderstood and maybe you needed to clarify some things?
My kiddos do attend a very diverse school, which is something we're really proud of. And I like to consider those teachable moments where my kiddos and I can have an honest conversation. They can give me more context about their feelings and the way they're interpreting something at school. Kids are going to question their surrounding. That's a normal part of growing. And my role as an adult, especially one that values diversity, equity, and inclusion, is to talk about our role as people in that system and our responsibility to dismantle white supremacy within it. I have frequent conversations with my kiddos about what does it mean to be a white person? What is whiteness? It's not something that they asked for, but it is something that they live with. And there's no need for that to interrupt their ability to build great relationships. But again, I'm their parent. That's my job to guide them through understanding these situations. And educators can be trusted to do the same thing.
Thank you. Further questions, Representative Dry?
Thank you, Mr. Chairman. Thank you for taking my question. What would you consider the banned concepts?
I think it's vague on purpose. It is difficult for the law to be interpreted accurately by educators. So the vagueness being, if you approach topics such as race, gender, those two in particular, or even ableism, ageism, any of the isms, it can put educators in danger of retribution from a minority of people who are looking to sow distrust within the public education system. So instead of putting their livelihood at risk, some choose to step away from even attempting to walk into those waters and have those conversations.
Representative Woodcock?
Thank you, Chairman Ladd. Thank you for being here. Almost good afternoon.
Yeah.
You seem to be very well connected with the youngsters, your youngsters. So as they come home from school, do you notice anything missing in your interaction with them in terms of information because of the Banned Concept Act?
I'm very lucky that my kiddos have very savvy long-term educators who feel confident in the teaching that they do in their classrooms. I cannot speak for every educator or for the environment that they teach in. So I think it has a lot to do with the community that folks are teaching within and their feel for the community and if they feel supported by their community in teaching such things. But again, if our educators don't feel that they have the support of the law to be able to teach the way that they feel is just and honest and inclusive, then they will miss things.
Thank you.
Thank you for the question.
Thank you very much, Representative Cordelli.
Thank you for being here.
Yeah.
I think you mentioned something about dismantling whiteness.
Yeah.
Aren't you stereotyping in place of maybe other stereotypes that this language is trying to get rid of?
I'm not sure I understand your question. Could you reframe it for me?
Sure. If someone said they wanted to dismantle blackness, I'm sure you would not be supportive of that kind of discussion. So why is dismantling whiteness
I think I'm
any better?
understanding. So the Black community has a very rich culture that is separate from whiteness, that involves ethnicity, different cultural experiences. Whiteness is not a culture. Whiteness is a structure that was established to create a hierarchy within our society. I am French Canadian. That's an identity, that's a culture. Whiteness is not. It's just a tool of a system. So yeah, I would very much like to dismantle a tool of a system that is being used to oppress other people.
Follow up.
And so, whiteness, is that saying that white people that's part of the structure that you want to get rid of in terms of any positions held by white people of authority? Or I'm not sure where you're going with that.
I'm not sure where your questioning is going with that, actually. I think there are ways that we can identify a structure that does not serve the entirety of our communities. I'm not asking that folks be removed from positions, only that we examine the ways in which we interact with each other and use different systems to keep people away from positions of power.
Representative McDonald.
Thank you, Mr. Speaker, and thank you for your testimony. I agree with a lot of what the prime sponsor stated the intent of this was, to be anti-discriminatory. I think the disconnect is along the lines of the word inherent. I know he mentioned that there were inherent groups that could be racist. Do you believe that there are racial groups that are inherently racist? And if so, is that something that we should be teaching in schools?
So I can only speak to my experience as a white person existing in New Hampshire and in the United States. As far as inherency, that feels like we're sort of playing with semantics. What I'm really concerned about is removing a bill that has put a chill on our classrooms and has made it difficult for educators to teach to their fullest capacity and has limited our kiddos from being able to learn to their fullest capacity.
May I ask a follow-up?
Yes.
Do you believe that there is any role in the department, and it is my understanding they have tried to correct the issue or clarify how the law is to be interpreted. Do you believe that could alleviate the chilling effect, as you put it, and clarify how the law is at least intended to be interpreted?
I think providing clarity to a bad law doesn't make the law any better. I think removal of the law is the ideal step forward.
Okay, thank you.
Yep.
Thank you. Representative Belcher.
Thank you, Mr. Chair, and thank you for your testimony. I just want to make sure I have a proper understanding as to your testimony regarding whiteness. You're suggesting that there was a historical construct that we call whiteness that was set up in order to reproduce itself and elevate a certain class, a caste of people in America to reproduce this culture of whiteness. Is that what you're suggesting?
Yeah.
And if I may have a follow-up, is that not the exact same language and theory of Karl Marx's theory of Marxism with whiteness instead of capitalism?
I don't know how that's relevant to the conversation that we're having here or how it's relevant to the bill itself. And I don't feel qualified to speak to Marxism, but thanks for the attempt.
Thank you.
Further questions from the committee? Thank you very much. Oh, Representative Peternell, did you have a question?
Yes, thank you. So I'm going to go back to, thank you, and thank you for taking my question. So I just want to use your concept of whiteness and insert it in the statute the way it's written right now. So, because there are various groups mentioned in this bill. So if we say no pupil in any public school in the state shall be taught, instructed, inculcated, or compelled to express belief in or support for any one or more of the following, that one's whiteness, I'm using that to replace color, is inherently superior to people of another color. It sounds like what you're saying agrees with what is written in the law, that you would not teach that your whiteness is superior to anybody else's color.
So first off, whiteness is not a federally protected class of people, correct? So then I don't have concerns. My concerns are for federally protected classes of people not being properly represented in our education. Whiteness is very well represented in education in the United States and in New Hampshire.
One follow-up.
The law as written mentions color.
Which people are
Does it
often,
not?
people are often discriminated against because of the color of their skin. You would agree with that, right?
Thank you very much. Thank you very much for testifying today.
Thank you, Mr. Chair.
Yep. I'd like to call Holly Wilson.
Thank you very much, representatives, for having me. I've shortened my speech to get right to the most important point. My name, excuse me, my name is Holly Wilson. I teach U.S. history and world history as well as English language arts at Ware Middle School in Ware, New Hampshire. I've been an educator and an alpine ski coach most of my life. I would like to tell you that I'm here in support of this to repeal the Divisive Concepts Law. And I like to tell you a personal experience. The outcome of that law has caused teachers to avoid controversial subjects, thus not helping students learn how to form their own opinion using facts and deductive reasoning. This law has created a sense of fear in teachers. It contributes enough fear that teachers will avoid those rich discussions, only give facts, and thus neglect the basic element that all history is gelled in, perspective and its formation. I experienced this firsthand when I unknowingly became wrapped up in this law. 2 years ago, I was teaching U.S. history and supplemented my curriculum with the young adult version of Stamped by Ibram Kendi and Jason Reynolds. I was so scared of this law, I studied it to make certain I was not in violation of the law before we read this controversial book in my classroom, which, by the way, was very entertaining, and the students loved it. It inspired rich discussion and debate in my classroom. Yet somebody who did not agree with the politics of it came into my classroom and anonymously took pictures of the decor, the posters that I had in my classroom, my lesson plans and notes, and turned me into the state in September of 2002, claiming I was violating the Divisive Concepts Law. Then, to top that off, our Commissioner of Education used them in an op-ed supporting his idea of family values in public education.
Your time is up.
Thank you.
Any questions? Representative Miley?
I'd like to thank you for being here. Thank you, Mr. Chair. I'd like to have you continue to talk about the impact of your teaching and what happened when that case was filed with the state.
Is there a question?
Yes. What happened?
Ultimately, the law was vague, and the DOE, the superintendent got involved, and the DOE sent all of my lesson plans up to the DOE, and they looked at what I was doing and said, there's no violation of any law, although they are not a body who would reprimand for breaking that law. It's so vague that no one could really pinpoint. And so ultimately, nothing happened. I was worried about losing my teaching certificate. My principal thought she could lose her principal certificate. And of course, ultimately, the superintendent's responsible. But
thank you.
So as a result of this experience that you had, what impact did this have on your teaching of history?
the impact that this has had on my teaching of history is I am very careful with the words that I choose with students.
Representative Tanner?
Could you tell me, or I guess I'll ask, did it change the dynamic between you and your students in class or fellow educators because this was all done anonymously?
100% of my students I spoke to about this and staff I worked with were in full support of me. Nobody said, oh yeah, you're not a very good teacher. You probably, I could see where talking about that book, you may have made kids feel, most of the population I teach are white, made them feel racist. None of that. I received a lot of support, and there was support from many conservative parents when I was trying to figure out who did this to me. And I did, in the end, find out who did it to me.
Thank you very much, Representative Woodcock?
Are you still using that guide, the book?
Yes.
Thank you.
Further questions? Thank you very much for coming today. Joanne Hamblett?
Thank you, Mr. Chair. My name is Joan Hamblett. I'm a state representative from Rockingham District 26, which is Portsmouth Ward 3, and I am a co-sponsor of this bill. Immigration is not poisoning the blood of our nation, but racism is. How can we end the scourge of racism that breeds fear, suspicion, distrust, hate, and intolerance in our country? Armed with true and accurate knowledge of our history and encouraged by teachers to discuss and examine the accomplishments and flaws of our policies, students will gain a deeper understanding of how history has influenced the beliefs and opinions we have today. We must not threaten teachers with disciplinary sanctions or civil action for allowing open and honest discussions in their classrooms. In fact, it is only with open and honest discussions that students can learn the underlying causes of racism and can then explore how to move us forward toward a more tolerant and peaceful society. I urge you to support House Bill 1162 to give teachers the tools and confidence to provide diverse approaches to instruction that encourage critical thinking and an understanding of how history affects our attitudes today. Let's end the scourge of racism once and for all by supporting our teachers and allowing openness and honesty to flourish in their classrooms. Thank you.
Thank you very much, Representative. Representative Damon.
Thank you. Could you comment how you think the current law might affect a teacher today who wants to help students look at the current situation in the Middle East and process the actions on both sides?
Thank you for the question. Yeah, that would be an important issue for teachers to discuss. But I think the law is so vague that teachers are afraid to dig into it very deeply.
Thank you. Further questions from the committee? Thank you very much.
Thank you.
House President.
Thank you, Mr. Chairman, members of the committee. Gilles Bissonnette on behalf of the ACLU of New Hampshire. I'm the legal director there. We are here in support of this bill. I'm going to be very brief. I know it's been a long morning. I do want to be very clear and just be transparent that I am one of the lawyers challenging this law. It is in court. A lawsuit was filed both by AFT New Hampshire and another lawsuit by two educators and NEA New Hampshire, filed back in December of 2021, about 4 or 5 months after the law was enacted. That is still going through the court process. There was a motion to dismiss filed. The court rejected that motion to dismiss. There was since a period of discovery where information, information was presented by the state to the plaintiffs, and then there was oral argument on what the outcome should be in that case. That occurred in mid-January. So we're just on the tail end of that. We're awaiting a decision. So I just wanted to make sure that the committee just knew, obviously, that there's some litigation on this law. And I'm one of the lawyers involved in it. And the reasons that lawsuit was brought are just the same reasons that I'm going to convey to you. The concerns that we have is that this law is so unclear and vague that it fails to provide necessary guidance to educators about what they can and cannot teach in their courses. And I think the ultimate concern that we have is kind of the ambiguity surrounding the concepts, but it's accompanied with real penalties, right, for educators. This has been bootstrapped into the Educator Code of Conduct. So, if there's a violation, there could be a whole host of sanctions, going all the way up to loss of license, which is one of the penalties under the Educator Code of Conduct. So the dynamic under this law, right, when you have ambiguous terms combined with real penalties for violations, it just creates a natural chill in classrooms with respect to educators not wanting to get anywhere close to the perceived line, whatever that line is when we're talking about race, gender, any of those things. So those are the core concerns that we have had throughout. And, I do just want to be very clear. I just think there is tremendous uncertainty among educators about what is covered here. Is Tiffany Jewell's book, This is Anti-Racist, banned under the Act, which is one of the books, it's for middle school kids. It's about, self-empowerment, right, including for students of color. Is that covered? And it was one of the books flagged by various proponents of this law.
Your time is up.
And we can't even kind of get answers as to what's covered. So I think that is really the underlying concern that we have throughout. So for all those reasons, we would just ask, and the reasons in my written testimony, we would ask for the support of this legislation.
Thank you very much,
you.
Representative Cordelli.
Thank you. Thank you for still being here.
Thank you, Representative.
Maybe you could point out to us, you mentioned vague terms.
Sure.
Could you point out a couple of vague terms to us?
Absolutely. How long do you have? So,
if you want to buy lunch.
let me just start with, there's really two, I'll keep it very succinct, just some of the core problems, but there are many, right? So look at band concepts 3 and 4, right? There are questions. Does this include instruction or even teaching or even discussing things like affirmative action, right? Which is a race-conscious approach to remedying racism. Well, I think arguably that would be covered under Roman numerals 3 or 4, or maybe not, depending on who you talk to, right? Could you teach Justice Sotomayor's dissent in the Reese's affirmative action case, which talks about the importance of race-conscious remedies? Could that be included in a discussion, right? Because it's not just the teaching that's banned under this law, it's shall be taught. We all know that in schools, it's not just teachers that are instructing, it's also things are done, can be done through kind of the Socratic method style, right? All of those things highlight the uncertainty that exists with this law, right? We all know that educators, like law enforcement and other professionals, have to make split-second decisions in the classroom. They need to respond to students and their questions and their concerns. And so with all of these terms, they just don't know where the line is, even to do something as simple and basic as to validate the concerns that a student may be presenting, right? So I don't mean to give a long-winded answer. I think that's just one of many concerns that we have had and why the litigation was brought.
Thank you. Representative Damon?
Thank you. Thank you for taking my question.
Thank you, Representative.
Could you comment about the existing law and how it could impact a health teacher or school nurse, perhaps, talking with students about body size and about the fact that large people are often discriminated against, for instance, in hiring decisions?
Yeah.
And how is that
I think that's a great question. And it is, one of the examples, right, is just look at kind of disability doctrine, right? One of the concepts that we have under the ADA is that we don't treat all individuals equally, but as a matter of equity, we actually give certain individuals, including those with disabilities, actually different treatment in order to create equity. We're actually, providing reasonable accommodations in part because of those differences. By kind of throwing disability in the statute, it kind of really, it creates these questions. Well, like, gosh, could you even talk about that basic concept? So I just want to put that example out there because I think it's even outside the race, gender context in which we kind of normally discuss some of the concerns we have with this bill. There are other areas as well. And I just think it shows the law's ambiguity, the kind of clunkiness, in just how it was originally written. I'm not accusing anyone here of clunkiness. I'm just, as a lawyer, kind of looking at it and trying to think about its practical effect.
Thank you very much, Representative Damon.
So if I were that health teacher and I, prior to this law, might have presented or fostered discussion with students around the possibility that a large person can also be a very healthy person, depending on their lifestyle behaviors and how they take care of themselves. Would I now be on a uncomfortable terrain to do that?
Well, you certainly would be if you suggested that, to accommodate that individual, to make sure that they have all the opportunities that everyone else has. They should be treated a certain way, maybe in ways that's different from someone else, in order to ensure equity in schools. I think that's actually precisely where you could be running afoul of this law's terms. And I'm sure that, the proponents of this say that's not what we meant, but, I think it's in the text of the statute, and when you combine it with penalties, boy, that's the recipe for real concerns.
Representative Dry?
Thank you, Mr. Chairman. Thank you for taking my question.
Thank you, Representative.
Is the intent of the lawsuit the same as the intent of this bill? And when are you thinking there might be a decision?
The relief that's sought in the lawsuit is a junction against the law. When there would when will that happen? I don't know.
I don't think we should be discussing that here.
I don't. The short answer is I don't know. But I just
Thank you
wanted to
very
make
much.
sure the committee knew.
Thank you very much.
Thank you.
Further questions? Thank you very much.
Thank you, Mr. Chairman.
Megan Tuttle? I don't want to get into the AG's office. and that's the bad direction. Good afternoon.
Good afternoon, Chairman Ladd, members of the House Education Committee. I will submit written testimony. I have 3 paragraphs to read because most of what I was going to say has already been said, and so I don't want to repeat anything in the interest of time. For the record, I'm Megan Tuttle, president for NEA New Hampshire, representing about 17,000 educators across the state. I'm also a mom of 3 boys that do attend public school, so this does affect me that way as well, and an 18-year veteran social studies teacher of 8th grade. NEA New Hampshire from the beginning has held that the current law's vagueness would have that chilling effect on educators throughout the state. We've watched this law in action for the past 2.5 years. We know it's true, and I can't say anything else other than what Ms. Wilson has said, and so I'm just going to leave the testimony for that, for how it's actually impacted them. Last thing, teachers are trained and experienced in education. They have a duty to set their students up to be successful contributors to society, and educators should have that freedom to teach honest, complete facts about historical events like slavery, civil rights, without having their licenses and livelihoods put at risk by the vague law. House Bill 1162 restores the ability to provide diverse educational approaches to instruction and curriculum that's tailored to meet students' needs. Our students deserve that freedom to learn. They deserve to be part of an education that helps them learn from the mistakes of the past so they're better prepared to succeed. And on behalf of NEA New Hampshire and our membership, I respectfully ask you find House Bill 1162 ought to pass, and I will submit electronic testimony.
Thank you very much. Are there any questions? Representative Woodcock?
Chairman Lynn. Good afternoon. Good afternoon. Quick question. Do you believe that your fellow NEA teachers have backed away from the how and whys since this, or do you think they just sort of said, forget about it and just gone on?
Thank you for the question. I absolutely believe they have backed away from it. And part of the lawsuit is a lot of those examples on what teachers have not done and what they've stopped doing from what they did before. And I know I've submitted those examples before as well. You're welcome.
Further questions from the committee? Representative Lekes?
Yes, thank you for taking my question. Do you believe that there's a difference between teaching that somebody believes that, let's take one example, that whites are better than blacks, or that is different or the same as teaching that there are people who believe that whites are better than blacks?
Thank you for the question. I do believe there's a difference, but what is happening with this law is educators are so afraid, teachers are so afraid that they're going to lose their license over this. They're going to lose their livelihood. And when you have that consequence as part of a law that's, I'll be honest, vague. I mean, that's what the lawsuit is about. And we asked for clarification on what could and couldn't be taught, specifics from the Department of Education and from the Attorney General's office, and never received any answers. And so what's happening is, I've been asked many times in this committee, what is vague about it? And the problem is it just truly is vague. Educators are too afraid that something's going to happen. They'll be brought up on an investigation. It's going to get through social media. They're going to be dragged through the mud. Their potential of losing their livelihood, their license to teach, is what's stopping them from teaching some of the things that people have said that they could still teach.
Thank you very much. Thank you.
Thank you.
I'd like to call Maya Engelbert?
Hello, my name is Mia. Long time no see. I might not be a lawyer or a teacher or anything like that, but like everyone else in this room, I have been a student. And I would like to tell a story. When I was in school, I learned, like most of you, that Christopher Columbus sailed the ocean blue in 1492. In high school, I learned there was more to the story than that. I learned about how he took the natives as slaves, how he subjugated them, how he stole the natural resources of the West Indies and brought them back to Spain. And I don't think that students could learn that sort of thing nowadays because it would make some people feel uncomfortable. And also, history isn't just a set of facts. It's a series of events that relate to each other. That what happened in the past is directly related to what's happening today, and we need the historical context to understand current world events. And I feel like I'm just rambling, but the point is, I think students can be trusted with not just facts, but how to interpret those facts. Not how to interpret those facts. They can learn how to interpret those facts in a way that supports their own worldview with facts and logic. And I'm definitely rambling, but thank you for listening to me.
Thank you very much, Maya. Are there questions from the committee? Thank you for coming today. Deborah Howes from AFT New Hampshire.
Hey, good afternoon, Chairman Ladd. Glad to be back here. My name is Deborah Howes. I'm here with the American Federation of Teachers New Hampshire, and just full disclosure, we also have a lawsuit against the so-called Divisive Concepts Law. We also don't know when the ruling will come down on that, but we'll keep you informed. Anyway, I am here today on behalf of our 3,700 members across the state and all the public school students that we educate in support of HB 1162. And the main reason we are supporting this is, as has been so ably testified to already, the Divisive Concepts Law is one we didn't need. It was a problem we didn't have. We didn't have public school teachers teaching any curriculum in the state that was instructing students that anyone was inherently superior or inferior to anyone else. It just wasn't going on as a curriculum. If there were individual instances, they should have been handled through the local disciplinary procedures. So that was casting a broad net and tarring all of our educators in the state with allegations that something was going on in schools that just wasn't happening. Getting rid of that law would really be a relief, because the effect of this law, this Divisive Concepts Law, has been to make the education all of our public school students are getting worse. They are not receiving the rich, robust instruction in history that they deserve. The teachers are concerned about teaching in ways where students are able to connect events to each other, to go beyond just the straightforward, here are the who, what, and why, and make connections between what happened in the past and how they relate to each other and what's happening now. You have language arts teachers who are concerned about teaching specific novels they have already taught in the past. They've always taught in the past. A middle school teacher who has always taught To Kill a Mockingbird has not assigned it since this law has passed. She is afraid of losing her license because she does not want to be brought up on a complaint under this law, even though it's been part of the curriculum in the past. And there has been exactly one complaint filed under this law since it was passed. One. So if this is such a problem that we need a law against it, how come there's only been one complaint? I do have written testimony and I will pass it
Thank you
around.
very much. Thank you very much. Other questions from the committee? Representative Lekis?
You said, and we've heard from others, that we're brushing teachers with a broad stroke by this law, that somehow we're saying that all teachers are bad. And I'm wondering, if we pass a law that says people should not steal, are we then brushing all people with a brush that says all people are bad because we passed a law saying what people shouldn't do?
You don't have to answer questions.
I don't think that really is a serious question. So
Thank you.
Yeah.
Are there further questions from the committee? Thank you for coming today. With that, we have no more pink cards up here, and we're going to close the hearing for 1162. We'll come back and start the next hearing at 1:15.
I'll be watching it on Saturday afternoon.
So we have more of this coming up right after.
Hi, how you doing? I just wanted to find a scribbled copy before I pass the rest.
I think we need to have a lunch and relax. Okay. At least I do. I got enough stress inside.
Oh, because she wants to get someone to cut a snip of tape out and post. She wants them to post it on social media. So.
Something just like
Yep.
to be on
Yep.
the mic.
It's a little bit after the appointed start time, but we'll move on to the hearing for House Bill 1671 relative to the complaint process for teaching discrimination and allowing educators and school officials a right of action for damages and costs for false accusations. And call on Representative Tanner to introduce the bill.
Thank you, Mr. Chair. For the record, I'm Representative Linda Tanner. I represent Sullivan 5, District 5, the beautiful towns of Springfield and Sunapee. And this bill that I did in September has two issues, basically, within the bill. First, it's the Code of Ethics. It addresses the Code of Ethics used as a weapon, that it was not meant to be nor should be used as a sticker of punishment for intimidating, investigating, or threatening the loss of a teaching credential for what and how teachers teach. The committee that wrote the code never meant to punish teachers for doing their job. And then the second part that I tried to address was I tried to give a Band-Aid for teachers who were wrongly accused and investigated, as well as boost morale by providing a bill that was meant to help teachers. I did this bill back in September, and I have to be honest that as I looked at the bill last week when I was getting ready for this, that the first part of it with the Band-Aid part is not written the way I would really like it to be written. It isn't precise enough. It's kind of vague and leaves a lot of loose ends. But the second part of the bill, the part about the Code of Ethics, I think is still really important, and that's why I'm here presenting this bill. You know, my intent was to stop and reverse the trend of unreasonable, unfounded attacks on public education and teachers, which demoralizes, threatens those currently in the classroom with the loss of their livelihood and dissuades those seeking to enter the profession. Therefore, I'm offering an amendment, which I put on your desk, Amendment 0499H, which is going to replace the bill and really focus on the Code of Ethics. And the New Hampshire Code of Ethics, I was around when it was developed. It had a really nice commission of a lot of stakeholders, and it was meant to provide professional educators with guidance for all school personnel. And it was laid out so that it would be well understood and easy to follow. And then as it progressed, after it came in, and it seemed like it popped up in various laws as the last little stick that, you know, this bill, if you violate this bill, it's considered a violation of the Code of Ethics. In fact, we got a technical advisory this morning that just about sent me off the roof from the Department of Education about the Code of Ethics involved with teachers talking to students outside of health and sex ed classes, which if you haven't read yet, you should. Anyway, as you can see, this amendment, what the amendment does is it takes the same language from the Code of Ethics. So the Code of Ethics, the New Hampshire Code of Ethics for professional educators shall establish guidance for all school personnel. And then the addition really is, and shall not be, in the Code of Ethics, it says it is not intended for, but I changed that to shall not be the basis for civil liability, nor a basis for employment action. And then the last sentence, again, is something that I added. Further, the code shall not be used to limit or restrict the educator's use of pedagogy or curriculum approved by the local school board. And that sometimes conflicts with, there's all kinds of conflictions with different state laws, federal laws, school board decisions, that sort of thing. I don't think sometimes people realize how hard it is for people who have worked in schools, for the teachers that come to testify or those educators listening to this committee meetings, to sit and listen to being disrespected, accusations, innuendos about our competency or professionalism. To spend hours listening to the persistent drone of bills based on problems that don't exist, on incomplete misinformation, or unfounded anecdotes taken out of context, on a distorted focus on student underachievement, and hear a total mistrust and disrespect for educators in the public school, and then have the professional code of ethics used against us. We have dedicated our career to public education, to teaching and helping students grow. We know the hard work and dedication that actually goes on into teaching every day in the classrooms around our state. We know the skills needed to meet the challenges and responsibilities with 30 or more elementary children in a classroom all day, or work with 100 or 150 middle school or high school students each day. We know what it's like to be that trusted adult for students, to celebrate their joy, and in the tough times, their sadness. We know the challenges we set before our students and see them succeed and reach those goals and beyond. I'm proud of all our public school students, teachers, and staff, and I thank them. Educators are professionals, and they needed to be treated as such. So that's the basis for my amendment and bill. Thank you.
Thank you. Questions for Representative Tanner. Representative Lakis.
Thank you, and thank you for taking my question.
Sure.
My question has to do with the NORA basis for employment action. And my understanding was that the very end of the Code of Ethics and Conduct section, the part that did have to do with employment, was reserved for very gross misconduct, such as sexually assaulting a student. And if we take that out, can we still use that?
This is still here. There's still a section in statute about dismissal of teachers. When I first started teaching, I was told that it was incompetence, insubordination, and immoral behavior, that those were the general categories that were left. I would assume, and I probably shouldn't assume, but in law, we have 21 different violations, which if that pops up in their criminal background checks, are ineligible. So I would assume those affect employment as well. And educators are supposed to reveal if that happens, if they get criminally charged for any of those things. And usually the public knows before everybody else knows. So yes, this is, like I said, the only change in this particular sentence is that the shall not instead of not intended to be, and the last sentence about the pedagogy and curriculum approved by local school boards.
Representative Myler.
Thank you, Mr. Chair. Thank you for being here. Since most of the committee was not here on this committee when the Code of Conduct was created, could you give us a brief history of how that was created and who are the persons involved in the creation of the Code of Conduct and the reason for the code?
I wish I had a copy of it right with me. Maybe somebody has one, but it was made to be a code of ethics and a code of conduct. And there was a commission formed to study it with all the stakeholders, teachers. Oh, here we go. Thank you. Thank you very much. So, excuse me. So it's this book, and Drew Klein was the chairman, who's also the chairman of the state school board. Or that's actually the state school board. That's not what I wanted. I thought I had listed the commission in here. The committee. Commissioners Task Force on Educators Ethics Membership. So it had somebody from the chapter of American Federation of Teachers, which we hear from, Christina from the New Hampshire State School Boards Association, Carl Ladd from the New Hampshire School Administrators Association, Dean Cascadden from the New Hampshire Superintendents Association, Diana Fenton, who we see periodically from the Department of Education, Diana Terrell, New Hampshire State Board of Education, Professional Standards Board, the late Doug Lay, AFT, Frank Hull, New Hampshire Council for Teachers Education, CTE, Gail Adams Davis, New Hampshire Association for School Principals, Helen Honoroll, New Hampshire State Board of Education, Irv Richardson, National Education Association, Kimberly Yarla, PSB, Public School, what is it? Professional Standards Board, thank you. It's nice to have the Greek chorus behind me. Laura Wasilowski, CTE, Lorraine Tacconi Moore, New Hampshire SAA, New Hampshire School Administrators, okay. Michael Perez, New Hampshire Association of School Principals, Nancy Morris, NEA, Noel Highmark, New Hampshire DOE at the time, Phil Littlefield, New Hampshire School Superintendents Association, Suzanne Canelli, CTE, Virginia Clifford, New Hampshire DOE. So as you can see, it was a large commission task force. It was had the stakeholders in it. I think they spent a lot of time on it, a lot of effort, and it is a good book for teachers and for people that are in the field of education. It was never intended to be put into statute as punishment or a stick for statutes.
Representative McDonald.
Thank you. Thanks for taking my question. Do you know if the Code of Ethics is readily available to educators in public, non-public, and chartered public schools?
This is online, I believe, with the Department of Education. And we had a whole bunch of them that were handed out. And I don't know if we still have any of these around or not.
This right here, yes. We don't have any more of these here in this office. We unloaded all those. But they were handed out to teachers as well.
Okay.
They're made available. So through the Department of Education.
Thank you.
And hopefully when they get credentialed, they get a copy.
That's when they get it.
Yep.
Further questions? Seeing none. Thank you very much,
Thanks. I
Representative.
hope you can support this.
I think that
Were there,
Representative, maybe we can get a card from you when.
were there any other cards for this?
No.
Then you need a card.
Yep.
Okay. So there are no more cards here, so we're going to close the hearing down on 671. And get ready to go into 1643.
I'm gonna have to look at my last year's folder because I was
saw that here.
beginning of it. But I think I retired it with it, not intentionally. I think I just had too much stuff to carry around.
I'd like to read it too. I know what we got going on. Also on this other business of who's doing what. Yeah, great. Who we have is speaking.
No, the first one, no, the first 416.
Okay. So you'll go along with, okay, great, okay. Oh, I'm sorry. Sorry. Yeah.
I think I'm gonna have to start putting, I had just now remembered that what I had figured out works when I get like this is to put eucalyptus oil, a particular variety of eucalyptus oil, on a cotton ball.
It's
I just said it.
not as bad as yesterday.
Well, I was thinking I usually set it next to my couch. And I'd forgotten about doing it. I think I'm going to have to do that when I get home.
A taser would be better.
And I can bring it
That's what I needed.
here and see if it bothers me.
Definitely on the struggle bus.
And if it does, I'll wrap it up and put it in my drawer until I can take it out or throw it away or whatever until I can take it home.
Okay, it's 6:47 or so, 48.
147?
Excuse us, yeah, 1:47.
Totally different size.
A long day. We're on 1643, requiring school districts to make curriculum and instructional materials available on their web pages. And let's see, we have no reps. Representative Electus, would you like to introduce that bill? You're co-sponsor.
Alicia Leckes, Hillsborough 38, Hudson and Litchfield. And I'm here to introduce 1643, requiring school districts to make curriculum and instructional materials available on their web pages. I think at one point when I was a teacher, this would have been complicated because I did lots of handouts that I did up and mimeoed off, but now we have computers. And so now, not only do I think it would be much simpler than it used to be, but I also have always appreciated those teachers who posted those things on the web pages every day or at least weekly, what they were going to be due. As a parent, it helped me keep up with what my kids were doing and make sure they got their work done. And that was really the biggest part for me, was making sure they were doing what they were supposed to be doing. And I know one of her teachers every day would post, this is what we covered. And given that I'd have been doing my handouts based on the computer, it would have been nothing for me to upload it. And it's not even asking for this as a daily, it's saying at the end of the year. But I appreciate when teachers do this on their website on a regular basis, because it just helps with that communication and with, let's face it, most kids don't like doing their homework, so it helps. That's all I have to say.
Thank you. Are you willing to take any questions?
I can try.
Okay. Well, let me start out with one. The title of the bill deals with to make curriculum and instructional materials available on their web pages. I go into the bill itself and I see you're referencing, the bill references in line 6, instructional material. But what, the curriculum, are they, how much are they supposed to be putting on the web page here, this curriculum, all these textbooks and?
Just what they are. I mean, if you go down farther,
go ahead.
You would say the book published by and the whatever version you're using. You don't have to have, you're not even supposed to put, because most of that is copyrighted. You're not going to put that on the website. You're just going to say we're using this book. Like I used a particular math book that the school provided, so I would have just said this math book. And then any additional stuff that I did, which I did a lot of, I would have posted. Oops, sorry.
Okay. Any further questions, Representative McDonald?
Thank you. What you just explained in terms of the books used, not necessarily the book itself, sounds similar to me to like a college syllabus. Is that kind of the intent of this?
That's my understanding.
Okay, thank you.
Representative Tanner?
Thank you. I'm going to talk about the lesson plan part of this and ask some questions and give some comments, I guess. First of all, this sounds something like I had in student teaching when they were right on my back and wanted to know what I was doing every minute of the day. As an experienced teacher, I didn't do this, okay? And so I don't know what you're digging for. I guess that's maybe the first question. What's your intent with this? What are you digging for when you ask for procedures for documentation review, approval of lesson plans, when you talk about volumes, the volumes of lesson plans from the year, and identify the teacher in part Section 2, Part A.
I'm not entirely sure what all of this was, what the intent was. I co-sponsored it because I thought there were some good ideas in it, but not because I understood completely the intent when it was filed. So I can't say that. I was looking at it not so much as a record at the end of the year, as an ongoing, as a communication between parents and teachers is an easy way of communicating what we're working on. And so I mean, as a teacher, if I assigned a particular homework assignment in the book, I would put that there so that the parent knows, okay, this is what's expected, and they can get on their student and say, is it done, right? I mean, I know I did that. Once we got to this online thing, and my granddaughter was living with me for her 4 years of high school, I looked to see what the assignments were and was she doing it. And that's what I was looking at myself. But the other part of that, I know parents want to know what's being taught. So again, you would put, if you use particular books, you'd put the book so that they would know. As far as at the end of the year, I actually don't know.
Now, follow up on that, please?
Yes, go ahead.
So the other thing about lesson plans, and I'm sure you experienced this as well, is that the best laid plans don't work out. And not only do they not work out, but a good teacher has a toolkit to bring up other things and work around that. And yet, this is the type of legislation that I feel parents want to know each and every little thing that you do, and then it's kind of a got you if you don't do it, or got you if you do it. So I was just wondering if I made a lesson plan for next Monday, and next Monday rolls around and it's a snow day, or next Monday rolls around and all of a sudden the kids can't figure out what I'm trying to tell them, so I'm trying to revise the plan and move around. How do I have to submit a new plan that's reviewed and approved before I can do anything, which is section top of page 2B?
I think at that level, I mean, nobody looked at every plan, every handout I made. I was always making handouts and quizzes and everything to try to get my kid, so I could see how they did. And that would happen daily, based on where they were, what they understood, what they needed more practice in. And I think where it comes for that is if you're planning on, like I used the book, and we had by department that these things would be done by these times, etc. I think that's what that's referring to, the big overall. And the plans, I mean, if I had had access to a website, which I didn't when I was teaching math, I would have done what the science teacher that my granddaughter had, was at the end of each day, put on there what we had done. And not in advance, but at the end of each day, because my papers would have been done on the computer and I could have just uploaded them.
Further questions, Representative Woodcock?
Good afternoon, Representative Lakis. I have a concern when I read the depth and breadth of this bill. I don't know when teachers are going to do it. At the end of the day, they're beat. Let's take a science teacher with 5 sections of 5 different preps in a high school and run that every single day. It seems like an enormous amount of work for limited value. I mean, they get it. A lot of teachers have their own websites, particularly in the middle and elementary. You can see some of the text they're using, but to put their day by day by day lesson plans and if the things happen to change, so the youngster asks a question that grabs you, that's the way it goes. You've already had it out here. I'd be petrified. Well, I didn't do the thing I was supposed to do because on the plan. I just think this is, it's almost like a big brother watching. And on the second hand, it's like, in the back of my head, I'm thinking, well, I'm giving you all the stuff I do in public school. You can take it and do it at home. Or you can take it and do it in your charter school. After I've done all the work, here's all the stuff you can do. And that scares me. So I just think this is a huge burden on teachers, time-wise, sex-wise. I mean, in terms of the text and that stuff, I don't have a problem with that, putting it out there. But they give out syllabus, at least in the high school, that's all I'm familiar with. They give out syllabus at the start of the class that has those things. We're not gonna, and I wouldn't want my students' parents to tell a high school youngster to check your homework, check your homework, check your homework. And we're trying to build maturity in these kids. The next day, John, you check your homework? Oh, we got a problem here now. Now we can start that communication, we start to build. What'd you miss?
I think
I like the concept in terms of the thinking behind it, Representative, but boy, I can never support this. It's like the Big Brother.
I think how much or whether or not you have to ask your child to check their homework depends upon the child. Certainly, I would have never asked my oldest if he did his homework or what it was. He was generally so far ahead of the school, I didn't worry about it. But I did have kids who I did have to check every day, or they did not do their homework, and they did not do well. And so having it available, I mean, if I didn't have to check my kid, I wouldn't be spending my time as a parent going on and looking. But if I did, it was a very nice resource. One of the teachers did it, but as I said, it was easy. I had to do these pages up anyways, so just to upload a copy of it would have been, almost no time. When I send it to print, I can upload it at the same time. It's not like I'm doing a lot. It's online and it's just upload the file. No big deal.
I understand the uploading documents. I understand the books. I don't understand the amount of time in terms of what you think is available for teachers. If you're an English teacher, you have to go home and correct or rewrite and help edit. Now they do it on the computer and the document. They have hours to do it afterwards. Why in God's name would they want to be spending it doing this? It's just going to be up on a website. They're trying to work with kids instructionally. Honestly, I just think this is way too much for teachers to do.
Further questions from the committee, Representative Cornell.
Thank you. Thank you for taking my question. This says it has a local fiscal note. The department was asked for on October 10th. Any idea of how much it will cost local?
No idea why it costs anything.
Because this is another downshifting to the local of another cost.
It may be. I mean, they're supposed to have a collective software document or spreadsheet to allow to update. So I think that, a Google Doc, I would think could just take care of that. And as a teacher, okay, I've done my thing. Now I have to print it. I just send a copy to Google Docs. It's done. I spend much more time creating that thing than to just send it off.
But we don't know.
Yeah, there's a lot. I don't know.
Further questions from the committee? Thank you very much. Pardon me? Are either the New Hampshire School Boards Association or the School Administrators Association interested in saying anything?
Good afternoon, House Education Committee Chairman Ladd. Thank you for taking my testimony today.
We are.
Becky Wilson for the New Hampshire School Boards Association. We are opposed to this bill. Last year, some of you may recall, there was a very similar bill in terms of posting curriculum to the website of the school district, which we also opposed at that time. First, we would say that RSA 186:11, Roman numeral 9-C already requires school districts to make curriculum course materials available to parents or guardians for review upon request. So certainly, while we would not like to suggest that a right to know request be put in every time someone wants to look at something from the school district, that's already covered under the right to know law and can be publicly viewed by anyone who wants to put in that request. We would, however, just suggest that a concerned parent or an individual speak with the school superintendent and set up a time to go in and look at whatever the material or instructional materials and curriculum that are being used are viewed between the parent and the superintendent. I would like to speak to the fact that there's a very big difference between posting a homework blog of what assignments are due the next day or that week. Most teachers do that already if they are teaching at an age where there's required instruction and homework that is available. That is very different than what the intention, it seems, of this bill is. This bill requires much more than that. It seems that the lesson plans of every teacher in every classroom for every block that they teach be posted on the website, not only for the current year, but for the year prior. So that is an extraordinary number of lesson plans. I was just doing some quick math in the back. I went on the DOE website, and because I was watching their deliberative session last night, Windham has 338 educators. If those people teach 4 periods a day, which is small compared to what most teachers would teach at a high school, it could be up to 8 periods a day, 5 days a week. That's about 1,352 lesson plans a day for that district, and 6,000 per week, 6,760. If you go to school for 36 weeks, that's about 250,000 lesson plans per year with no straying from what you have created for that day's lesson. If you have strong educators who are doing formative assessment during the class and changing up the lesson plan, I'm not sure, you could be doing 4 or 5 lesson plans per period, so you could multiply that times 5 or 10 or whatever you want to do. So this bill is really focused on paperwork and administrative tasks, not really the art of teaching or any pedagogy. A list of books is not descriptive of what curriculum or instruction is. So while I appreciate if that's what the intent of this bill is for, then it should just say a list of books. It shouldn't talk about curriculum and instructional materials. While I appreciate that the sponsors of this bill tried to define that, it's still very vague. I don't know if it applies to students who are on an IEP who potentially have individualized instruction blocks. Are their instructional materials going to be posted online for people to look at? That seems like it could be concerning. So the last point I would make is it's very important to consider whether the district even has the storage capability technology-wise to manage this bill. I understand that it seems like it might not be a cost to the district on its face, but I will tell you that storage, especially with information that is related at all to students, has to be kept at a very high level. Last year's bill, I know that's not what we're talking about, said, well, we'll just combat this problem by offering the district could hold it all physically somewhere. But if you go back to the example I just gave, that's, 500,000 lesson plans for 2 years. Where are you housing that, online or otherwise? So there's absolutely a fiscal impact to your local district. It may even involve having to hire more tech staff just to do that. Teachers are not uploading their documents as they make them, according to this bill, because they have to be vetted by some sort of admin process. Each lesson plan has to go through some sort of approval process that is posted also on the website. And lastly, the bill does create what appears to be a possible statewide lesson plan template that would come from the department. I'm not sure if that's something that would make people more or less comfortable. And the effective date is July 1 of this coming year, but it requires last year's lesson plans to be posted. So how are you expecting districts to comply with this if it goes into effect on July 1? We're already in February, so where are this past semester's lesson plans? I'm happy to take questions.
I got a question for you. Having been a teacher, Becky, I ask you, in looking at lesson plans, especially when you were in the area of special education, did you ever in your lesson plan book said, today I'm going to meet with a small group and we're going to be dealing with whatever's on that IEP? So there's a reference to how many times you had the contacts and all that. Is there any confidentiality to that lesson plan?
Thank you for the question. Yes, is the very short answer to that. Oftentimes, again, when I was an educator, I ran a program for students with emotional behavioral disorders. So those students had some similar needs, some different. We ran lots of social skills groups, which targeted certain emotional and social needs that those students needed to work on. You needed to keep track of that in terms of your compliance with federal IDEA regulations, in terms of making sure you're meeting services, et cetera, and tracking students' progress. But of course, the names of who are in those groups or what you're working on, et cetera, that would not ever be something that you would want a special educator be posting online.
Thank you. Further questions? Thank you very much. Oh, Representative Lekes.
Sorry, thank you. I'm reading and rereading and trying to put all this together. And a number of people have talked about lesson plan is in that thing you write up as to what you hope to accomplish that week. And here it seems like it's a past tense lesson time, the instruction provided of all instructions assigned, distributed, etc. So am I reading it wrong? I see it as a past tense as opposed to what you were planning on doing. So maybe lesson plan is not the right term?
Thank you for the question. I wouldn't want to try to define what the sponsors of this bill meant by lesson plan. I don't know what the intention is of having to post the lesson plan, because I'm not really clear, as you said, on what it is that's being posted. If it is a syllabus or a list of materials, that's very different than what an educator would call a lesson plan.
That's what I was wondering. Thank you.
Thank you. Further questions? Thank you very much.
Thank you.
Mr. Frew, welcome.
Thank you, Mr. Chairman. Jerry Frew, Associate Executive Director of the New Hampshire School Administrators Association, and I'm here today to express our opposition and concerns with this particular piece of legislation. The first thing that came to mind in reading the title, an act requiring school districts, the first question that came to mind was, should this also apply to public charter schools to make curriculum and instruction materials available? That was the first question. In line 7, there's reference to other reading materials. And I'm sure that those of you who have been in classrooms and in education circles might be familiar with the fact that in many elementary school classrooms and middle school classrooms, teachers have classroom libraries available for kids to choose a book, read a book during, rest time or downtime or wind time or any time. And so would this include listing all of the materials in those classroom libraries that are accessible and available for kids to look at? Line 21, lesson plans used during the prior school year. The question is, what is the purpose of that? It seems to be an onerous administrative burden and teacher burden to include. I just don't know what the purpose of including the previous year's lesson plans would be. It's already difficult in a timely way to do an on-time or in-time lesson plan. I'll make sure I hit everything. I do want to appreciate Representative Lekes' acknowledgement of the hard work that teachers do to kind of keep their heads above water every day. It's not an easy business. It's not like when, I won't speak for you all, when I was in school. I think it was a simpler time. And my teachers worked real hard. And some of them worked real hard just to get me through their coursework. And thank goodness that there wasn't a parent portal on the web where my parents could go in and see whether I'd gotten my homework done or not, or how I'd done on a test or a quiz. Because that's the current reality, folks. Parents can access grades, they can access course materials, they can access lesson plans, they can access what's going on in the classroom. It's included in program of studies, it's included it's accessible for anyone who wants to pick the fruit. The fruit is there for the picking. And I think it's important to acknowledge the hard work that teachers put into having that done already. We don't need a state law to have a gotcha with you didn't get this requirement done, you didn't get that piece done, and so we're going to sanction you somehow. This is local work, and if a local school board wants their teachers to post things on the web, then they can say that this is an expectation of employment in the school district. We want you to do this. It has collective bargaining implications. This is a lot of work, and all due respect, it will cost money, and there's no money in here to help support this particular additional work. Teachers are going to have to take additional time to upload things, and I won't restate the things that Becky talked about in terms of storage space and all those things that become then district problems to mitigate. A high school teacher could have several preps in each day, and you're going to differentiate and personalize instruction. Do all of those pieces have to be posted on the web? Where do you want teaching? Where do you want time to go? Meeting bureaucratic regulations and laws passed down by the state of New Hampshire, or do you want it to be invested in teaching and learning with children and remediation and supporting their individual needs? Because there are only so many hours in the day, folks. And oh, by the way, if that teacher in that classroom advises a club or coaches a sport, they then may have to contact, based on another piece of legislation that you heard this morning, they may have to go home and call parents to see if their nickname kid, Flash or Sparky, if they have permission to call the kid Flash or Sparky. So when does all this get done? There are only so many quality hours in a day. Don't know about you all. I get tired at the end of the day. Thankfully, the teaching profession has wonderful people that are used to working 12 hours a day. I can't do that at my age anymore. It's tough. People work really hard, and I think that we have to be mindful of the fact of what we already asked them to do. Tests and quizzes are instructional materials. Does this mean it says instructional materials have to be posted? Tests and quizzes are going to be posted on the web as well. This says instructional materials. Those are instructional materials. So I think this is well intended. I also would bring to the attention that 3 of the sponsors of this bill are from the North Country. And I find it puzzling that an observation that 3 of those sponsors represent the North Country, probably the region least equipped to have curriculum directors and additional teachers that have time to review things. They don't have curriculum. We experience that right now. We have a group of curriculum and instruction and assessment folks from the state. We don't have anybody on the North Country that can afford 1 hour a month to come to a meeting to get support in curriculum instruction and assessment from their colleagues. How the heck can we ask those small school principals, because that's where it's going to land, to enter all of this information on behalf of their teachers or to support their teachers? And I cite another small, and then I'll stop. Promise, Mr. Chair. I'll cite the small community of Hill, okay? Only because I'm familiar with the situation. Brian Conley is the superintendent. He's the principal. For a while, he was a special education director. For a few days, he was the cook because the cook got injured and couldn't come to work. And so then you're going to say, oh, by the way, Brian, you've got to interrupt. If your teachers aren't available or able to enter their curriculum materials, guess what, Brian? Good luck. Now you're an administrative assistant for yourself. So I think that this is the transparency of knowing what kids are doing in school is available to people now as they want to choose it. And I'm not quite certain that this bill serves any great purpose. If you support increasing the burden on teachers and administrators and taxpayers, then you'll support this bill. If you feel that the energy of teachers and administrators need to be put into kids and instruction and learning, and you're serious about not wanting to increase burden on local taxpayers having to pay for the increased cost due to the implementation of this, then you'll find this bill inexpedient to legislate. Thank you.
Thank you. I have one question for you, Jerry. As a past principal, as a past teacher, we had a little book called the Plan Book. And in the Plan Book, we put down what we were doing, whether it was reading math, social studies, whether reading about Elie Wiesel, the Holocaust, or book Night, or whatever. It was put down in there. Are you saying that this still being done in schools? I've been out there since 2004 out of it, but I would assume that this is being done by teachers still.
Thank you, Mr. Chairman, for that question. Yes, extensive planning is taking place on the part of teachers. And unlike my teaching experience, when I might say, I taught 4 high school classes of social studies, very different levels, senior theory, political theory, down to New Hampshire history and government level 4, when everything was leveled, there were very different pieces of my day. And the plan book would be very cryptic, for lack of a better term, 2 or 3 words, cover this topic. Today, teachers have much more extensive planning that they illustrate, what technology they're using, what competencies they're measuring that day. The administrators have to have planned observations and walkthroughs, and the administrative burden has increased. So, all due respect, Mr. Chairman, the plan books that you and I filled out in our days of teaching, they belong in a museum these days.
Is it safe to say, though, in the left-hand drawer, the right-hand drawer, there is a plan book for when the teacher is absent for the substitute teacher?
There's a stack of plans like that when a teacher is absent for a substitute teacher.
So plans are occurring.
Yes, sir.
That's what I'm trying to say. Further questions? Representative Myler.
Thank you, Mr. Chair. Thank you for your testimony. Dr. Frew, you've outlined a fairly rigorous program that current teachers are, and I'm assuming that is based on your previous role as a teacher, as a principal, as an assistant principal, as a superintendent. So you've seen all the levels that have gone through, and it's based upon that experience that you have that you view this bill as being much more intrusive to the learning and instruction process based on your education experience.
Thank you, Representative, for that question, and yes, that is correct.
Thank you.
Any further questions? Thank you very much. Is this on this other bill, Kim? This is on this one.
It's on this one.
Representative Horrigan. I thought we were all done.
Okay, thank you. I just, anyway, I feel like a few pretty severe reservations of bill. One thing that's common to a lot of these bills is talks about what the school board is supposed to do. There are public charter schools, and I guess there's other school, and there's similar schools that don't have a school board. I guess usually we tend to interpret these bills to mean that the board of the charter public school stands in place of the school board unless it's a charter public school which has a school board, which some do. So that's one big ambiguity in this. Also, like the lesson plans, not every child in the classroom is necessarily following the exact same lesson plan. They often have customized materials for children who either need help getting up to the grade level or above the grade level. So there isn't necessarily just one lesson plan, although that's probably, and also there's licensing issues with the contents. Most of this content is copyrighted, so we may not even, some educational publishers might not even want to let us use the materials here in New Hampshire if they can put them in a website where like anybody can, look at it, pirate it, copy it, etc. And also, and this is probably by design, but it seems to be set up so anybody can object to what's being taught in the school, even if their child is not in school or if they're not otherwise directly involved. And I suppose I can see the rationale where the taxpayer dollars are paying for it, but that can be a lot of problem. You could have somebody who's, doesn't have a child in the school, isn't, maybe not, doesn't even live in the school district, taking up the school board's time or the chartered, or presumably the charter schools board's time, on disputes which maybe don't really have anything, because they're upset about the material, like even though it doesn't really directly affect them at all, what's being taught in the classroom. So I think this bill is, just looking at it, seems poorly thought out and it goes too far. So certainly, if you do try to pass it, you probably need to address just some of the issues that I've thought of and many others which I hadn't thought of, because I just signed up for 3 to 2 minutes and on the fly, so I didn't do any prepared remarks. So I think this bill certainly should not be passed in its current form. If it is passed, it needs pretty major changes. I would suggest either ITLing it or sending it to interim study. And in any case, what's being taught at school is certainly not a secret from the child, and hence it's not a secret from the parents. So I'm not sure, I'm not really sure who else. So I'm not really sure, who else is directly involved in it that even, should be objecting to it, certainly, especially if it meets the curriculum standards. So that's why I think this bill is a bad idea. So I would just put in my 2 cents and say you should definitely not pass it. So thanks. I'd be happy to take any questions.
Thank you. Are there any questions for Representative Horrigan?
Yeah.
Thank you very much.
Thank you.
We do not have any other cards, so we're closing this hearing, and we're going to move on to the next bill which we have before us, which is 1235. Yeah, 1235, relative to high school students serving as school board members. Welcome, Representative.
Thank you, Mr. Chairman. Thank you, members of the committee. My name is David Rochefort. I'm from Grafton 1, from the great town of Littleton. And Littleton has the distinct recognition of being the largest town north of the Notch. We're not a city. We have the city, but the largest town north of the Notch. And really, it's even despite the fact that we have the largest town, we have some problems that I think we're going to hopefully address today. HB 1235 was actually brought to me by a teacher in the school, Mr. Jeremy Brown, who you have a copy of a letter that he gave me yesterday. He came to me 9 months ago with a problem that hopefully we can solve here today. And it revolves around the bill, the law that came out of here a few years ago that put a student on the school board. So the school boards are required to have a student representative, which I know him and I both agree is a wonderful opportunity for these kids. And it's good for the school board to get feedback from the students to understand really what they're doing. But in a small town like Littleton, and I say it's a large town, the largest town we have is a population of 5,800. We have our own high school, but the problem that we're having up there, because the school is so small, we are having a problem finding enough students to fill this position. When you take, just to give it perspective, my daughter graduated from Littleton High School last year in a class of 35. So it's not a huge school, but they do have participation, but they have desire for participation in this. But the problem is we just don't have the students to do it. When you take students who are active in sports, extracurriculars, after school jobs, it limits the ability, it limits the pool that we can draw off of. And the reason why is because it has the current law has one student representative and they have to attend all the meetings. So if you have one student who has to attend all the meetings, it kind of takes away from their ability to do sports, work, etc. So if you look at the bill, what we've done here, we worked with him, and this came from him. This came right from the teachers with the recommendation on how to make this better. And he proposed that the student government shall determine the number of student school board members. So it could be more than one, but not more than 3. Up to a maximum of 3, and establish procedures for each of them to share the responsibilities that are defined in paragraph 4. And then the other thing that we change in this is just the attendance, that rather than attending all board meetings, they have to attend at least one school meeting per month during the regular school year. Of course, we know these school boards meet year round. And this adds a little more flexibility. It makes it a little more friendly and attractive for students to get involved. And it's an opportunity that we want to succeed, but we think it will succeed, more likelihood of succeeding with these changes. So pretty simple. And I'd entertain any questions that you might have.
Thank you very much. Representative Cordelli?
Thank you, Representative, for being here. I'm a little bit confused by a few things in here. I gather from what you said, the intent is for a shared position. Now, a school board can elect to have more than one student representative. So how would that work in your bill?
So the point that he wanted to do, the objective he wanted to achieve is actually have this student elected, chosen by the school council, the student council, the student government within the school. He thought that by including the student government in the process, you get a better participation from the student body rather than keeping it segregated to a school board.
Follow-up question?
Thank you. Yeah, on line 3, it says that a student member shall be chosen by the high school student body. But then on line 7, the change you make is that student government shall determine the number of school board members up to a maximum of 3. So is this school board determining the number of student representatives on the board? And it seems like there's a conflict about who chooses the student representatives. Is it the high school student body is in lines 3 and 4, or is it the student government?
The intent was the student government. So I think that the line 3 probably should be updated to, or line 3 and 4, where the student body, that probably needs to be changed to be reflective of the student government.
One more.
Yes, go ahead.
Okay, then down in the line 16 and 17, where they're talking about the duties of a student school board member. If there are, as indicated in lines 8 and 9, up to 3, I guess, who would represent each one of the school board members, who could share that position, would each one of the shared school board members have to attend at least one board meeting per month?
So the intent was that at least, I believe he defined that in there. But in speaking with him the other day, was that the intent was that at least one of those student members would attend at least one meeting per month. You know, the constraint that they had on every single school board meeting was not attractive to attract students to participate in this. So, you know, what he was, you know, considering and what his feedback was, you know, if we could get at least one meeting attended per month, that would attract more students into this.
Thank you. Further questions? Yes, Representative Cornell.
Thank you. And thank you for taking my question. I'm confused on how this would work in Manchester, where we have 4 high schools. So they each have a student representative on the board. So there's 4. And I think they take turns attending the full meetings, and then the subcommittees are divided among them so they can choose which one best fits them. But they are chosen by the high school student body because each senior class or junior class, whichever year they're elected, has 500 students. So they run for the whole class. If it's just elected by the student government, the 4 class officers are picking who they want to represent them instead of the whole school student body. But if this gives up to 3 per high school, we'll have 12. Or we won't have enough.
I see where you're coming from with
Yeah.
that. Yes, yeah, and again, this was really school specific to how fixing a need in a small school.
Yeah.
Whereas, you know, you got at the other end of the spectrum there. But if we could and I'm not averse to, you know, I mean, it's your bill now, and I think you know the need. If this committee can come up with some type of resolution that can accommodate these smaller schools, where we're not being able to fill those positions because we're so small. I mean, you've got the opposite problem in that. You don't have a problem. You don't have a problem. This bill would not be a problem as written for a school like yours, where the bill as written is a problem for smaller schools like mine.
Further questions? Just rolling around in my mind right now, how would this work in a cooperative school district where you have many, many districts? And even with a system where you might have a K through 8 and they tuition their high school kids out to another district, would the district that's receiving these tuition students, in this particular case, allow for a student to be on that board of the receiving school if they're from a district that's sending tuition-wise, and if it's 20 miles away from the school, or 10 miles away from, which may happen?
Yeah, I don't think the law speaks to that now or as proposed. I think that's even though, because as the law is now, I don't think that addresses that question.
Other questions? Representative Damon?
Thank you. Thank you for taking my question. This could be me, but I'm not 100% sure that the language clearly states there will be at least one. It says up to a maximum of 3. I mean, maybe you can read line 3 into 4 to confirm that there will be at least one member. I have to say, I'm coming at this, my first elected office was junior in high school board member, and I learned a lot from it.
So I think the one comes from line 3. A student school board member shall be chosen. I mean, so that's where you're defining something you have to have one there, and then line 8 is where it defines the upper limit of that.
Okay. See, Roman 1, that's not here under this, says you can have one or more. It's not in this part of law. It's the first part of the law. So I'm getting really confused on how this whole scheme is going to work.
So,
Representative Damon, you had the floor. I'm sorry for butting in.
No, that's quite all right. And actually, I just wanted to follow up on your prior comment, Mr. Chair, and hear from the representative. Would it seem reasonable that tuition students would be eligible to be school board reps if they were elected by the student body where they're going to school? Why does it matter that they're a tuition student, they're a student at that school?
I can't think of a reason why that would matter. I mean, the goal is to get students involved and to be a conduit of information from the students to the school board. So I don't understand. I don't see how that would be a problem.
Any further questions, Representative Cornell?
Yes, thank you. The RSA now says one or more students from among its members to be non-voting members. So so do we need to change it to say up to 3 when it says one or more already in the RSA? The RSA already says one or more.
Yeah,
In a different section, a different part.
In Roman 1.
In Roman 1.
Right.
We're in Roman 2 here.
I get her point, though. It already says more than one, so we don't have to add that in 2 because it already says it.
Becky, do you have something back there that can? Okay.
So, and again, if that is adequate, if that addresses what he's looking at, then I would also, but I would also contend that 16 and 17, line 16 and 17 move through, where there's not a requirement for attending every single board meeting year round. That's another barrier to entry, if you will. So if we're comfortable with paragraph 1, no Roman numeral 1 addressing the number, then we could keep that the way it is. But I would ask that the committee keep line 16 to 17.
Thank you.
All right.
Any other questions? Thank you very much for coming today. Yep, we already have a pink card for you, Becky.
For the record, Becky Wilson, Director of Governmental Relations for the New Hampshire School Boards Association. We are not taking a position on this bill, but I did want to try to clarify, I think, some of the questions and concerns that were coming from the committee, as well as maybe provide a little situational context potentially that we've heard about over the past year since the original bill was passed. So initially, when this bill was passed last session, 2 sessions ago, they're starting to blur in my mind, quite honestly. The challenge was that, or the intention of the bill was to require that every high school in a district had a student representative on the school board and that position was an elected position. It has been very common practice for many years for school boards to have student reps, but not all of the student reps were elected by the student body. They were appointed, or maybe they were elected, or maybe if you were the student president, you also were the student rep. So there was different ways of becoming the student rep. That bill clarified that position has to be an elected position by a majority of the student body. So this bill, I believe, doesn't necessarily require that you have more than one, but if you wanted to have up to 3, those would all need to be elected positions. And as you might know, we've talked about it before in conjunction with the New Hampshire School Administrators Association. We have held 3 training for student reps over the past year or so, representing about 30 different school boards, about 50 student members. And we have heard from student school board reps, sometimes it is a challenge to balance the role with their other obligations. That's work, sports, other after-school activities, family life, etc. Because they are full members of the board, other than non-voting, for many of them, the expectation is not that you're just giving a board report and leaving the board meeting. The expectation is you are a full member of the board, other than for certain exclusions, non-publics, etc., and that you just can't vote. So the expectation for some of these students is that they are remaining at the school board meeting for the entirety of the school board meeting. Some school boards only meet once a month. Some meet every other week. Some in some of the cities have their regular meetings every other week plus committee meetings. So depending on how districts are interpreting this role and how the student government is sort of outlining this role, you could have a student who was at school board meetings many times per month. So this would allow the student government not to appoint student reps, but all the student government would be doing is determining the number of elected positions, I think, and what that would entail. So if you want to run for student school board rep, this is what that means. You go to 1 meeting per month. Maybe it's the full meeting, maybe it's a committee meeting. However the student government wants to define the role, they aren't telling the individual reps what they're supposed to be doing, if that helps with that. We also, over the past year since the original bill was put into place, have had an occasional situation where a student rep would be unable to attend school-sponsored events. And I will leave it at that without getting into a lot of context for some particular reason. However, because they are in their elected capacity, they are still expected to go to school board meetings. That has created some challenges for those districts. I'm happy to provide more general context if needed. The board can't exclude them from the meeting because they are elected as part of the school board. At the same time, they are not maybe available to attend school-sponsored events. So if you had additional school board reps that are student reps, this would give you some flexibility in terms of how to handle those situations and still meet your obligation of having student voice on the school board. I'm open to answer any other technical questions.
Cordelli?
Thank you. Thank you for helping us out with this. You mentioned that you believe lines 7 and 8 indicate the number of elected representatives. But that's really a school board responsibility to determine the number of student representatives on the school board, isn't it?
Thank you for the question. Not the way the current statute is. The current statute mandates that you have to have one.
One, right.
That is elected by the student body, and the way this bill is written, the student government is deciding if you want more than one elected position and what their role is.
Follow. So basically, this language is superseding the will of the school board, who might say, we want one representative for on this, a student on the board, but this is indicating the student government can overrule that and say they want up to 3.
Thank you for the question. When the initial bill was put forward, the intent of that was to have student voice on the school board. It was
Right.
not a school board requested position. So I believe that the intent of this amended language in this bill, allowing the student government to determine how many people they want, would not be out of line with the original intent of having student voice on the school board.
Further questions, Representative Damon?
Thank you, and thank you for your help with this. I was interpreting the representative introducing the bill to be suggesting that having more than one student representative would not necessarily be an increased number of positions, but more of a job share. Or it could be either of those. But would you comment on the idea of 2 or 3 students sort of holding a position that they rotate so no single one has to attend all the meetings?
Thank you for the question. So currently, there are a number of school boards and student bodies who have 2 school board representatives. I'm just going to use that as an example. Often it is a junior and senior, for lack of a better criteria. And the intention of that is for the junior student to come in and kind of understand and learn the role of the student school board member, so that when the senior person graduates, they can elect yet another junior student rep, and then the senior, and so forth. So in some of those situations, what's currently happening in practice is perhaps not both of those reps are staying for the entire meeting. Perhaps if one of them has something else, the other person is staying, vice versa, or they have, between the 2 of them, figured out how, okay, I'm going to provide a school board report for the K to 6, and I'm going to provide a student rep report for 7 to 12, however they've divvied it up between the 2 reps already. For towns and cities that have more than one high school, you have already more than one rep, because you need to have one from each high school. This would allow each high school to have additional members, so that if somebody were unable to attend the meeting, that particular high school's voice wouldn't be silent at that meeting.
Further questions, Representative Lekis?
So do you think that the lines 7 through 9 are necessary in order to do what the intent of the bill is as far as that part goes? Or do you think the fact that it says 1 or more students in the section 1 before this is sufficient to cover that?
Thank you for the question. I think that the section 1 that's not on here requires a student school board rep to be elected. I think without some clarification, it might be confusing as to what about if there are more than one rep? Do they all have to be elected? Are some of them appointed? What's the role of those people? So if you want it to be aligned with the other language, I think, and again, I don't know the sponsors of this bill specifically in terms of what the intent was, but it seems to me the intent was to allow the same process for these other additional reps, which would be they would be elected and the student government is running that election. It's a, race with the student body, and they are electing those people and deciding who's doing what.
Thank you.
Further questions from the committee? Not seeing any. Thank you very much.
Thank you.
Are there any other cards on this one? With that, we're going to close the hearing. Okay, the next bill we have, and the last bill for today, is HB 1616. It's relative to parental consent for student participation in Medicaid to Schools program. Representative Cordelli is here to present the bill.
Thank you, Mr. Chairman and honorable colleagues. For the record, Glenn Cordelli, representing Tuftonboro, Wolfboro, and Ossipee in the beautiful Lakes region. And I'll keep in mind that this is the last bill of the day. But this bill is pretty simple in its intent. I think my goal with this bill is to give parents more oversight in terms of what's going on with their children at school. Currently, if you take a look at the basic one-page bill, there's Section 1 and Section 2. Section 1 is related directly to Medicaid to schools, and I've passed out the latest required DHHS annual report on Medicaid to schools. And you can see in school year 22, we're talking about over $13 million in federal Medicaid reimbursement to New Hampshire schools. So it's a healthy sum. And right now, it is required that written parental consent is required in order to bill Medicaid. But that's only required one time. The intent here is that whenever there is billing for a new service, as indicated by a different service code, diagnostic code, that there would be written consent. And at the same time, before the service was offered, was applied, there should be written consent from the parent also to that service. So two things. For the service, there has to be written consent, and for billing, there has to be written consent. The second part is already in statute, RSA 227A, also related to the consent of parents. And I just try and replicate that requirement in this area of statute so that, again, parental consent is required for each new service based on the diagnostic billing code. So I think it is pretty simple in that regard. One reason I started thinking about this requirement was testimony we had, I believe it was last year, or it might have been the year before, with Medicaid to schools. And there was even testimony from the Department of Health and Human Services that there had been parental consent being required online for the billing to take place. But due to a previous change by a previous administration, that consent was eliminated, and the department was working to bring back basically the required written consent. So I started thinking about, do we want billing or consent just one time, and then it's carte blanche to bill for or offer any other services that student, possibly without the parents' knowledge. So that was the genesis of putting this legislation together so that parents know about what is being offered to their students in school in terms of services. So I thank you.
Are there any questions from the committee? Yes, Representative Damon.
Thank you, Mr. Chair. Thank you for taking my question. I actually have two. So one is to clarify, it references diagnostic code. I'm wondering if maybe that isn't supposed to be procedure code? you don't bill for a diagnosis usually. You bill for whatever procedure or service is provided relative to a diagnosis.
I'll take that under advisement. I did work in a medical center for a decade, and I was very familiar with ICD. Then it was IDC 9 codes. I think now it's 11, 12, who knows what it is. But, and I did talk to a former nurse about this as well. And that's when we agreed on diagnostic, but, we can look into procedure codes as well.
And then may I?
Follow up, yes.
So the other question was just to confirm, it sounds like the bill is requesting two consents. One for the parent or guardian to consent to whichever service it is.
Right.
And then a separate one to consent for it to be built. Is that correct?
Correct.
Okay.
Representative Myler?
Thank you, Mr. Chair. Thank you for taking my question. Once again, I see here on line 16 that you're using the code of conduct as a punitive measure. Is there a reason why you do that?
It's really just to ensure that the consent is being obtained, primarily because it wouldn't pertain to the billing necessary, possibly to the billing. But when we see that the system is not actually requiring that consent now, I wanted there to be some form of remediation or penalty, if you will, for the elimination of that which is required by law.
Yes.
Well, on that, I mean, isn't there another alternative other than using the code of conduct? For example, school district could implement progressive discipline, for example, rather than using the code of conduct in a way that it wasn't meant to be.
Other alternatives?
Further questions? I do have one in Representative Cascadden. On line 14, it says any educator who orders, refers, prescribes, renders, or provides services. If the IEP specifies goals and objectives for this particular student, and the speech pathologist or the nurse goes ahead and prescribes some of these services, is the IEP enough? Or do you have to go back and every time you do this, do you have to get support or approval from the parent?
If it's required. Thank you. You'd think I would know by now, wouldn't you? If it's required in the IEP and the parent has signed off on that IEP, then I think we could make an adjustment there.
Representative Cascadden?
I was thinking around those same lines, if it's a 504 plan or an IEP, if there's a change, an addition, or a deletion of a service, that team has to convene and get parental permission. But the members on the team are not privy to who's a Medicaid student or not. That's all internal within an office that connects the student's name. So an educator can't just automatically call the speech person and say, I want that student to have more time. It doesn't happen that way. The parent has to be at the table. If there's a need for more time, then it's a team meeting and they have to sign consent for that. So I don't know if you've got specific examples that identify what additional consent, because students on Medicaid is confidential information. So providers don't know which student's on Medicaid and which is. So do you have any specific
I do not have any specific information.
Representative Lekis?
My question is also with that section, Roman numeral 9. But my question is, what about an emergency situation? Is there an exception for that?
Exception for what are you looking at?
I was looking at an emergency situation, for instance, EpiPens. There wouldn't necessarily be prior parental consent, but you wouldn't have time to get it either.
Right. I would see that emergency situations, like we talked about with that specific bill, emergency situations could be handled differently. But whether you would still need parental consent to bill for that, that we could talk about.
Okay.
Further questions, Representative Woodcock?
Thank you, Chairman. I'm still hung up in the punitive nature of item 9 to start with, and if an educator is doing an action and the parent has already had to sign off on it, because that's how we're doing the action, because they have to come back to the team. I don't understand why there is a double issue here, that if they do that, then without the second signature, that it's punitive. They've already agreed to it.
Yeah, as we discussed, if this is in the IEP and the IEP has been signed off on, then I think that we could modify this language.
Okay, so thank you. So when would this occur that a student wasn't in an IEP? Did they have prescribed services? I mean, 504 is not an IEP, but still prescribed service.
I believe that there would be children who qualified who did not have an IEP. And perhaps someone behind me can speak to that.
Thank you. Thank you, Mr. Chair.
Further questions? Yes, Representative Damon?
Thank you. I think I asked my in the weeds question and I should have asked the broader question first. Is there a perception or awareness of a problem in the utilization of Medicaid for services in schools?
I think a couple of things. One, we had heard that there was in terms of getting parental consent. Two, there are new guidelines that have been coming down from the feds, and I've had correspondence with DHHS, and they are looking to modify rules based on new guidance. So, whether those new rules will include, alternative written consent from parents, I'm not sure. But I wanted to get out ahead of that in terms of this requirement.
Yes.
Has there been communication with DHHS about this bill?
It was in relation to specifically the new federal guidelines that were being worked on and the new rules that would accompany that. Have they seen the bill? I am not sure.
I have a question that follows up from our discussion when we had the last Medicaid to schools type debate. If in fact the parent or the person that's qualifying for Medicaid working with HHS checks off on the box that I agree to the person at the school, be it the nurse or whoever, doing what you're saying right here, does that then take care of the responsibility of the school having to do this?
I think in that instance, it's a one-time checkoff. I'm looking for each new service being provided, and I hope that possibly that checkoff box has been made available since our last discussion, where it was not available.
Further questions from the committee?
One more.
Representative Woodcock.
Thank you. Thank you, Chairman Ladd. A follow-up to Chairman Ladd's line of thinking. If the parent checked off that I would like my child to receive free reduced lunch that they're qualified for, would this count as a direct service? So
No, I don't believe so.
why
Because you're not billing Medicaid for free and reduced lunch.
for Medicaid? Okay.
Further questions? Thank you very much.
Thank you.
And so, let's see what we got here. The public. No, I wanted to get somebody from the department, HHS, but I don't see anybody here. No, Office of the, we have Office of the Alaska for Special Education. Kristen. Okay, I'd like to have Kristen Mancharamani. How about just M?
Fine. Is it possible? I would love to speak after Ms. Archibald, if that's possible.
Sure. Okay. Is it Janin Archibald?
Thank you, Chairman Ladd. Thank you, members of the committee. My name is Janan Archibald. I'm representing One Sky Community Services. We're one of the 10 area agencies in New Hampshire that represent individuals with developmental disabilities and acquired brain disorders. I sit here before you in support of this bill. And the reason why I'd like to put a face to the impact of a piece of legislation like this. You know, we all go to the doctor and we sit there for the first 15 minutes and they ask you questions. Have you received your colonoscopy? Have you received this test? Have you received that test? And you sit there and you answer yes, yes, yes. And you sit there politely for a little while until the 10th or 11th question. And then you're finally like, okay, how come this is not in the system when the doctor you're questioning me about is literally right next door to you? And there's no comprehensive database, even for shared doctors under the same office. Now imagine being a parent of a child with a disability. You go to the primary care doctor who refers you to Dartmouth for a test. You go to Boston for a specialist. You go to someone on the South Shore for therapy. And then the one common denominator amongst all of that is the parent. They're the ones who can answer the questions when you go to the next doctor's appointment, the next therapist. Has your child had this service? Has your child had this test? You know, that might not be recorded in the system. There is no perfect continuity of care in the healthcare system. So knowing that, and now what we're faced with in this situation with Medicaid to schools is we're seeing an expansion of services, which can be great. A lot of offerings here, but now there's regulations coming down with the Safer Communities Act. There is free care system that's being adopted that does not require parental consent for services delivered and billed directly to Medicaid. There also, with these new legislations, you can bill outside of an IEP. So services might be provided and you don't know what type of service that is. And that might be okay for your child who's healthy and has a good suite of care defined. But for a child with a disability, that might not be okay. You might have a child that doesn't react well to a certain therapy or treatment. And the only common denominator at this point in time, till we get to a place where we have a great system of continuity of care, is the parent. So it's really important to a child's health that they're tied into all of the care decisions. They might not choose to do anything with it, but the fact that they're armed with that knowledge can only contribute to the health and well-being of the child. So that's why I urge you to consider passing this bill.
So I got a question for, would school personnel be billing outside for services outside the IEP of any kind? Or would they all be associated with the IEP or 504?
There are new guidelines coming down. One is, I think Moira will talk to this, with the Federal Register that does not require parental consent. And then the free care policy, which allows schools to bill outside of the IEP. It's called a care policy, I believe.
and if you know, who generally does the billing within the school district? Is it the individual provider like the speech therapist or nurse, or is there a billing office that does that?
Well, I can't claim to be an expert on school Medicaid billing. I have been sitting in on some of the training to try to grasp this, but it will be different for, I think, every school. They might have an admin, or they might ask for a third-party biller to handle their billing. So it will depend. I don't think some schools might not be doing it at all, from what I understand.
Thank you. Are there questions? Yes, Representative Woodcock.
Thank you, Chairman Led. Good afternoon. Just a follow up on the free care piece that you talked about. It's coming down. The rules are coming down. If their parents are not required to sign off on that free care piece, I think that's what you said, then why would does the state have the power to overrule that federal guideline? I thought the federal guidelines always took precedence over state.
I don't know.
Is that your question? I'll wait. That's okay. You don't have the answer. I'll wait.
Yes, you'd be better suited to answer that. Thank you.
Thank you, Chairman. I'll wait.
Thank you. Further questions? Yes, Representative Cornell.
Thank you. Thank you for taking my questions. Are these new rules in effect? Those have been like passed through whoever the government and passed down to New Hampshire? Yeah.
So the Safer Communities Act, that was 2014. So yes, that one. And the Federal Register is not accepted, not in effect yet.
Follow up?
Yes.
So the Free Care Act is already in effect in if I didn't get the name right, but school districts can already provide services without telling parents?
May I defer your question to Moira, who's much more knowledgeable on it than I am on the specifics?
Sure. Thank
Okay,
you.
thank you.
Further questions? Thank you very much. Representative Ford?
Thank you for taking my questions. I'm curious about the authority to make that determination that you just spoke about. Where is it? Who has that authority to make the decision?
The Federal Register?
I don't know.
Oh.
I'm ignorant on this matter.
Well, that would be the federal government, and I printed out a copy of it if you'd like it.
Thank you. I'll get it afterwards.
Sure.
Further questions? Thank you very much.
Thank you.
So either Moira or Kristen, whichever is best to come up next. Fight it out. Thank you. Duke it out back there.
No, I'm not a fighter.
Okay. Moira Ryan, welcome.
Thank you, Chairman Ladd, and thank you, Education Committee members. My name is Maura Ryan, and I'm a parent of a son who has autism, and I would like to support this bill. I'd like you to consider it. And I'd like to describe some of the situations that parents have with Medicaid schools. So one of the issues that has come up recently, I met with Roberto Cardona in Washington, D.C. to discuss the Federal Register. So the Federal Register is a rules-oriented body. So they're not really in touch with constituents or the public or parents, and they make rules changes by publicly posting them, and very few people know about the Federal Register. And I pointed out to him that that might not be the best idea, but they do rules changes that way. And they did post something where they were gonna, in an effort to streamline processes, eliminate parent consent for services. That is problematic to me for the very reasons that Ms. Archibald had said. You know, I have entire volumes of coordinated care for my son because I have documentation of all his surgeries, I have documentation of all his speech language, I have documentation of all his OT. I am the one who is the primary care coordinator because I coordinate with the IEP team in the school, but I also coordinate with the medical model or the neuropsychs, the developmental pediatrician, et cetera. And I'm the only common in between those two because the medical model and the educational model are not in sync. They were in sync when the Education for All Handicapped Child Act was passed in 1975, but they've diverged in recent years. So they're operating under two separate systems with two different goals. So one of the issues that has come up with parents that's very critical is that if they go to their primary care physician and they say, I'd like to take my child to do outside speech and language, and the physician writes a referral for 2 times a week speech and language. And the school has said 1 time a week, 15 minutes. You now have 2 competing opinions on what the child needs because the insurance does not recognize educational versus medical. So if I went to my private insurance and I said, I'd like for my son to get these services in school, they would say to me, well, the school is required to provide those, so you have to go to the school. But Medicaid doesn't necessarily do that because there's a blurring of the lines there because some kids are getting services in school and some are not. So some of the parents have been complaining because now we have 2 competing opinions where the school person is saying this kid only needs 15 minutes once a week and the physician is saying 2 times 45 a week. So it's been creating some turbulence because the parents are saying my outside services are being pulled or limited or changed because I have 2 competing opinions or because they're getting this service and they want to cut it down on the outside or however it's happening for them. They're finding that they're not getting the services that their kid needs because medical model and education model are completely different entities. So with those competing, with that competing situation, it's putting the parent in the middle, which isn't fair either. I mean, if there's one thing I would like to see happen, theoretically, it's that an EOB be given to the parent for the Medicaid to school services so they can actually track the services their kid is receiving and make sure the kid is getting, all the outside and all the inside in the school. I'd also like to point out, too, that schools don't have the obligation to follow HIPAA. It's not the same as a medical. And what has been happening in schools is, yes, you're correct, Representative Cascadden, no one knows who has Medicaid. So what the schools have been doing is they've been handing out the form to everyone. And if the parent signs it, then they'll bill. And if the parent doesn't sign it, then they won't bill. Or they might try and bill, without the consent. But they're not asking. They're just giving everyone the form. And if it comes back signed, they'll attempt to bill. In the emergency situation that you had mentioned, Representative Lakis, there are separate laws that cover emergency situations because the government recognizes that we don't have time. If somebody needs a defibrillator or something like that, and the school has the right to act, and they're protected under like a Good Samaritan style law, especially because of the emergency of the situation. One of the programs where it's outside of an IEP would be like the Renew program, which is a mental health coping program. So basically, with Renew, that is covered by Medicaid. So essentially, when the programs were being rolled out in schools, administrators would say to teachers, please tell me who you would recommend for this program. Who would be a good fit for this program to learn coping mechanisms because they are having trouble or difficulty. And they got back tons and tons of kids and they didn't know which ones had Medicaid. So they just sent everybody and they saw how it washed out. But Renew would be a program, which is a mental health program, which is outside of an IEP where they could theoretically have someone be retaining services for counseling or coping, other things like that. I do think it is very important for the parent to be informed because there was one case where a child had an allergy and they didn't know they had the allergy. I don't know if the parent had discussed it with them or what happened, but they were given something they were allergic to and they had a serious allergic reaction. And the kid ended up being fine. Everything ended up being fine and there was no problem, but the child wasn't aware they had the allergy. And I know my own son, he tells everybody he has no allergies. He's allergic to wool and nickel and all kinds of stuff. He's just not allergic to any prescription drugs. Another key component of the parental consent, if you've ever taken the volunteer advocate training through the Parent Information Center, they do say to work with the school district to sign off with the billing, but to make sure that the services are correct and accurate. And they also advise you to, it's a way for the parent and the IEP team to work together in tandem as opposed to sort of negatively. I also just wanted to mention too that you had put in here for some reports, and I think that's a good thing because in my particular town, the Medicaid to schools money goes to the town and then it gets transferred to the school and it's not addressed in the budget. So I think it would be good for this committee and everyone else to know how much is being spent on Medicaid to schools, how to improve it, and how to make sure kids are getting their services. So with that, I would like to support this bill. I'm happy to take any questions.
Questions from the committee? Several years back, Representative Balboni.
Thank you, Mr. Chair.
and thank you for taking my question. I'm still confused. I apologize for this.
No problem. It's not easy stuff.
If your child is recommended for services and you get the IEP and you sign off and you know exactly what services your child is getting, correct?
Theoretically, yes.
Okay. If anything changes with the services, they're required to reconvene and and they can't do anything unless you sign off again.
Well, theoretically, that would be accurate, but in practice, that's not how it works.
Okay, and the second part of that would be the billing aspect. This whole thing seems to imply that schools are abusing Medicaid reimbursement. And so my question would be, if you're signing off that your child is getting that service, and then if you have Medicaid, and we've talked about the service providers don't necessarily know that, and you're checking the box, I guess I don't understand why that would be a problem. They'd just be applying for Medicaid reimbursement for services that are being received.
Okay, so you're asking me why I wouldn't know if services were being billed for? I'm sorry, I'm not sure what your question is.
I guess the question is, I don't understand where the disconnect is unless there seems to be an implication that the schools aren't following the policies.
I don't think that's the implication. I actually think that they're not familiar with the medical model, and I think that that's created some issues. I think they need some help. I mean, I don't know if I was here in 2019 giving testimony before this particular committee on when Medicaid to schools required that people in schools have medical licenses, so they issued medical licenses, and that sort of was a new component. And, that's something where now we're trying to function within the educational model and the medical model, and they're really not the same thing. So I do think that there's some differences that need to be worked out there. I would agree with that.
Thank you.
I was going to ask you, you have a youngster that's ages 3 to 5, not yet in school, but also receiving Medicaid support via working with HHS, and has certain services in the home, maybe wheelchair or other equipment. Now the child is in kindergarten in the school system. Do the providers that are going to be providing that support, maybe it's a physical therapist or such, or a nurse, do they have to reapply for these services, or is the service that they got through age 3 through 5 directly through HHS? We have had this discussion before, and even if the equipment would even be available, if it's already 24/7 to the parent, then is the school eligible to get those services? I don't even know where that is anymore. So I guess I'm asking the first question. Do they have to reapply as a provider of that service, that physical therapist or nurse, again, if it's already been done in ages 3 through 5 directly with HHS?
Right. Okay. So the short answer to your question is yes. And part of the reason is because it's coming from different pots of money. So services 3 and 4 come from early intervention. And at 5, it transitions over to the programs that support LEAP, kindergarten, and K through 12.
Thank you. Further questions? Thank you very much.
Thank you. I hope I answered your questions.
Okay, Kristen?
Good afternoon, Kristen Moncharmani, advocate for special education here in New Hampshire. I want to address some questions that I think I've heard from everyone about whether there really is an issue of parental consent, especially for those children on IEPs. And by way of background, one of the things I'm concerned about with my agency, and as we hire staff, we'll definitely be looking into ways to get at this, but there are a number of IEPs that really are operating with sort of implied consent, because there is a provision that if parents do not either explicitly consent or explicitly object and refuse to give consent, after 14 days, the IEP and the services go into place if the LEA has made reasonable attempts to obtain consent, but that reasonable is not defined. It's a matter of discretion. I would tell you there are probably a startling number of implied consent IEPs in place right now. It's something, again, we have an information system that may not give us all the information we need on special education and IEPs. There are a lot of concerns about how it operates, but one of my big priorities for the office would be to get to that question of how many IEPs are out there with implied consent as opposed to an actual parental consent written. So there are probably a large number of instances where you don't actually have signed parental consent for the services in place. This cannot happen the very first time a child is referred, right? So if a child is referred very young, in order to begin an IEP and begin to give services, you don't have any provision for implied consent. But for a lot of children, these IEPs go on for years. So after the first one being put in place, yes, there are absolutely kind of implied consent services being provided. And I would worry in terms of whether parents really know exactly what those services are, who those providers are, whether those providers necessarily conflict with something else or some other advice they're getting from a pediatrician. If it's happening via implied consent, I could see even the most well-meaning of school districts saying, okay, we have this disability determination or identification. We have these goals for this child. There are times when the district is modifying exactly how those goals are met, and some of those modifications are absolutely sometimes in who the service providers are who are delivered to that child. Is it an occupational therapist? Is it a speech therapist? Is it a school counselor for psychological counseling? Is it the special education teacher? And so there would be a whole range of situations where I could imagine that parents would not be aware of services determined to be medical in nature and billable under Medicaid that were being delivered in the IEP. So this is just another tool, again, to make sure that that partnership between district and parent is strong and that there are opportunities to discuss, because it's another incentive for school districts to say, look, okay, we didn't manage to get the consent. We do want to bill these services to Medicaid. I'm all for the schools getting all of the reimbursement money they're entitled to for providing services. We need to make another effort to make sure to go back and say to the parent, what is it about, you neither refused nor consented. We're going to try again because we have services we would like to bill. Let's figure out where the issue is. For a lot of the parents that I work with, when they're not happy with the IEP in whole or they don't understand it, they just don't act, which is not the most irrational thing. For a lot of us, we assume if I don't sign something one way or another, then it can't go forward without, it's just not necessarily true. So they might be acting in a way that is rational, thinking, okay, I'm not going to give consent, but there is a default background operation where services still are going to be provided and could be changed, and service providers could be changed within the school. So that would be a situation that this bill would address.
Thank you very much. Are there questions from the committee? Representative Damon.
Could you please clarify for me from your remarks just now? I don't understand how occupational therapy services would be provided by some other professional who's not an occupational therapist, or similar examples of what you just said. That's against licensing standards, and they're not trained to do that.
I would think it would be more often, for example, a question of whether, let's call it communication, social communication services for some sort of communication disorder were provided initially maybe by the school counselor in a group session and then transferred over to a speech language pathologist. That speech language pathologist might be Medicaid billing situation, maybe the school counselor is not. With occupational therapy, sometimes you're talking about fine motor skills. And some of that might be addressed by a special ed teacher, which then transferred over to say, let's have an OT seeing this student. Is that a good or a bad thing? I mean, often it would be a good thing to go to more specialized providers. All that this is looking for, as I read it, is that we make sure parents really are informed of what's happening. It's a positive for parents, even if they're then able to, as Moira said, provide that information to their child's physician because they understand they were asked for consent. They know who the service providers are who are delivering services to their child.
Further questions, Representative Woodcock?
Thank you, Chairman Led. This is very quick. So, in the fail-safe process, which is explaining to Representative Damon over here, at the worst case, wouldn't the parents have already agreed that, yes, I want my child to have this service, and they signed that up on the IEP. And you're saying it's provided, say, for someone in-house at the council, a small setting for social skills. And then the school finds someone who can do the same thing or more qualified in Medicaid. It's still the same service. And they assign it to person X, whoever it happens to be. So they haven't changed the service. The parent's still getting the service as provided in the IEP. And minimally, wouldn't they normally see that at the annual review? If there's not going to be a team meeting called because they really didn't change the service, they aren't circumvented, just find a different provider. But at the annual review, wouldn't they see that we either eliminated the service or we changed the service, or the service hasn't changed at all?
So, two things. One, the parent may or may not have agreed to the specific service, right? The parent may have said somewhere at the outset of their child first getting an IEP, yes, I agree either with the school team's referral or I myself referred my child for a specific disability identification. Right. And then a set of services maybe flowed from that the first time. It is probably more common than not that over time, the service delivery grid and the providers change as the child gets older, as their behavior changes. There is no requirement that a parent sign off. If they had a disagreement going with the school team that we wouldn't really necessarily even know anything about, it may or may not impact this kind of service provided. If they simply did nothing, the services that the LEA was recommending go into place. So I think it's more that type of situation where a parent could really not be aware. Now, do they become aware at the annual meeting? Yes, they should if they attend it. And if the school team focuses the parent on the service delivery grid, which is the only place that the provider is really specified anywhere in the IEP. My experience is most IEP team meetings don't focus on that service delivery grid. They focus on much broader discussions about the goals for the child, et cetera. So I think having an explicit consent requirement makes everyone more informed.
Thank you. Representative Wright, just a question to you. Is it possible to get some comment from DOE Special Ed on this bill?
Well, I absolutely think we need to. I've got a question. NHHS, for example, if I have a speech therapist in the school and the IEP says twice a week you will have these meetings with a youngster. And so you're billing based on billable hours and you rack them up. But the second time each week, it's delivered through a paraprofessional, not the speech pathologist. And this does occur. Is that service provided by the paraprofessional under the supervision of the speech therapist, who may not even be at the building at the time? Is that a billable hour to Medicaid?
So it's a question I don't know the answer to, but it is an example of the type of thing I'm talking about, that you may have services provided by different professionals.
Okay, we've got an answer back there on that one. Maybe. Okay, further discussion. Thank you very much.
I apologize. Sorry, Chairman Ladd, could I address one other point?
Sure.
Just to say I do support potentially looking again at Section 9, because the Educator Code of Conduct is something that, we're struggling to use in various specific situations. It doesn't very well address, as it's written, this kind of behavior. So alternatives are definitely something to look at, in my opinion.
Do you have any ideas for us?
Not yet. I can think about them.
Think of them,
Thanks.
please. Okay, I'd like to call Becky Wilson. Welcome.
Thank you, Chairman Ladd, member of the committee. Becky Wilson, Director of Governmental Relations for the New Hampshire School Boards Association. We're not taking a position on this bill. I just wanted to clarify a few things and maybe put some questions out myself based on what I've heard from other people who have testified on this bill. It's important to recognize, at least from my perception of listening to the testimony, there's two different conversations happening. One seems like a conversation that this bill is trying to address about billing for Medicaid to schools. The second seems to be about teams disagreeing when they get to the service delivery page of the IEP on services a child might need that are educationally required or based versus medically required. Those are, in my opinion, two totally separate conversations. Medicaid to schools, the consent that parents sign for Medicaid to schools only allows the district to release personally identifying information to a billing company to bill for services that might be medically necessary in school. There's no one on the IEP team specifically, typically, is doing that billing directly. It goes to whoever the district is contracting with to do their Medicaid to schools billing so that they can release the fact that that child is getting services, and the third party can decide and look and see if the child is eligible for Medicaid. And if the parent has provided consent for all of those things to happen, the school district can put in for some services and recoup a small amount of those services back to the school district. That money comes in at the end of the school year. It's retroactive reimbursement. It's not provided up front, so it has nothing to do with whether or not kids are actually getting the services on their IEP page. It's revenue that comes back to the school district in a check that then towns and districts can decide how they use their revenues, whether they put it in unexpended fund balance or carry it over, or whether it goes to offset the tax rate. That is the Medicaid to schools piece of it. In order to bill for Medicaid to schools, you need to have a medical order. A medical order can only come from certain practitioners. An educator does not count as a person who can put in a medical order. That comes from people like speech pathologists, OTs, potentially developmental pediatricians, other medically based PT, audiology, all of those pieces. That person that is looking at the service page of the IEP is deciding to quote unquote order those services because they are saying that those medically based services are required for the child to be able to access their educational environment. That's why you can bill for Medicaid to schools. It has nothing to do with the child's personal Medicaid benefit or anything like that. And the consent that the parent is signing, they can sign it every single year. It can be withdrawn at any time. It's just to release information to allow somebody else, because I think it was said earlier, district staff can't know who's Medicaid or not Medicaid, to allow them to release the information so that the billing can decide if they qualify for Medicaid to schools and the school district can recoup some money. The other situation that it seems like is being talked about a lot, and I certainly don't want to minimize it, is a disagreement when a team gets to the service delivery page of an IEP and is trying to decide what services are required for the child to make progress on their IEP goals. There is sometimes a difference between educationally necessary services that are required for the child to make reasonable progress on their IEP goals and access the general ed environment versus what a child might need medically from a medical standpoint. So there are times where teams don't agree on that. But that is, in my opinion, a separate issue from Medicaid to schools. As far as the implied consent, I just want to clarify that is one of the standards we've talked about before, that New Hampshire has a higher level of implied consent requirement than the federal IDEA. So you can't just do something after 14 days if the parent doesn't respond. You have to have documentation of telephone calls to the parents, other attempts made. You have to send information requesting consent or response from a parent, regular mail and certified mail, before you can ever do something with implied consent. And even then, there is a small list of things that even if you don't get any response from the parent, you can't do. That's the New Hampshire special ed statute for that. So while I'm not trying to discount any experiences, I think that probably these things are happening in some places, and that is why you put into place the Office of the Special Ed Advocate so that they could help to manage some of those things. But the implied consent is not just that nobody talks to the parents and then they get nothing back and everything moves forward. I'm happy to try to answer any other questions.
Questions, Representative Myler?
Thank you, Mr. Chair. I'd like to make a little point of order here. This is like the fourth time Ms. Wilson has been here to talk about special education. She has a vast background in special education, but that is not her role here. Her role is to represent the School Boards Association. Mr. Chair, I'm concerned that there's a lack of attentiveness on the part of the Department of Education, Special Education Department. They should be here answering these questions, not Ms. Wilson. And I would ask the chair to talk with whomever you have to over in the department, that when we're talking about special education, that representative should be here, not Mrs. Wilson, because that is not her role, even though her clarifications are perfect.
I have already talked to Becky Wilson regarding this. She's coming here as a school board member. We've talked about that. In fact, just within the last several days. And she has that background in special ed, a real good background in special ed as well. When we introduce these bills, I agree, I would like to see somebody here from Special Education DOE. However, when we get to a point where we are right now, there's no question this has to be put to a subcommittee and we need to be doing some work. I still got mega questions myself regarding this. We went through this even prior to the present management administration at DOE. And I don't know if we've ever gotten resolution on some of the questions and issues which exist out there between putting an order in and who does the billing. I can remember that, for example, speech therapist that I talked to just the other day, a caseload of 70, 75 kids and does the billing. Now that's one heck of a job. So there's a lot of issues which we got to look at, especially when we're talking about Medicaid to schools and other components of special education. So we will take care of this, and this probably most likely will go to a subcommittee.
It's not an early bill or anything.
It's not an early bill, that's right. We got lots of time on this. We got another month. So, and we can also interim study it, but okay. Thank you very much. Are there any more
You're quite
questions?
welcome.
Thank you. And David Trumbull?
Thank you, Mr. Chairman and committee members. I'm David Trumbull from the town of Ware. I have some concerns about the bill, but I just want to back up and go over the special ed aspects of it. I think that the code of conduct punishment model is totally inappropriate for this sort of situation. You've heard that the billing system is extremely complex, and despite extensive questioning, it's not clear. You've heard that sometimes parents won't show up to certain meetings, and so that leaves people in limbo. There's obviously the question of, can you find service providers in certain locations? Instead of a punishment model, I would suggest a training model that you would say, if a school is out of compliance with this, that you will find people who know how this system works and make it available to them. There's no reason to punish teachers, and it was indicated that teachers really have nothing to do with the billing. The second thing is that let's step away from the special ed cases. It's not clear that this bill only applies to special ed cases. I looked up the code, and there are other things besides special ed that applies to the ICD codes. For instance, social determinants of health, which according to the AMA are responsible for 50 to 70% of an individual's health. So these are social risk factors associated with poor health, such as food insecurity, housing instability. And there are ICD-10 codes for homelessness, inadequate housing, and food insecurity. We know that 60% of school teachers regularly give food to their children. Under this bill, that would be, I think, if the language of the bill says to render or provide services, if this teacher gives food on a Friday afternoon and tucks food into their child's backpack, that's rendering a service for an ICD-10 code. I don't think that's the intent of the bill, but I think it should be looked into more so that it's clear that if this is just a special ed bill and only special ed, then it should be stated as such in the bill so there's no confusion whatsoever. The other question I have is, well, what about transgender students? Because trans also is an ICD-10 code. So it's very vague here. What is rendering or providing a service? If a child is a trans student, is using their pronoun rendering a service? Is having books available for them? If a child is on puberty blockers and the parent comes and tells the teacher that this is happening and the teacher tries to make some accommodations, is that somehow providing a service? What is a referral? What if a parent confronts a teacher about their trans child and the teacher refers them to a family counselor? Is that a referral? And even in that case, how would the teacher even know if the student was a Medicaid student or not? And as it was clearly pointed out, teachers aren't supposed to know that. So there's just, I would like it to be very specifically stated that this bill is only dealing with special education. If teachers provide food or make a referral to a housing for a family who's become homeless, they're not going to be punished under the code of conduct. And that has nothing to do with transgender students. It shouldn't have anything. If it's a special ed bill, it should be clearly stated as such. That's all. I just think it's a little bit unclear. And as you said, if you go to study committee, perhaps you can straighten out those things. Thank you.
Thank you, Mr. Trumbull. Are there any questions? Not seeing. Thank you very much.
You're welcome.
With that, I don't think we have any further pink cards up here on this bill, so we're going to close 1616. And that closes down the hearings for today. This committee will meet again tomorrow. Representative Ford.
Thank you, Mr. Chair. One of the witnesses that we spoke to after the hearing asked me to make an announcement. It's about a television show that they recommended that we all watch, if I may.
Sure, go ahead.
It's a show she described as Stampede. I think it's a show on one of the specialized shows that you can get on the regular TV situation. It has to do, she said, to be sure to watch it from the beginning. It's called Stamped, not Stampede, I misspoke. Stamped, S-T-A-M-P apostrophe D, I guess, or D, you know. But that's the name of the show, and they recommended it all to you.
Thank you.
For everyone. They also made the observation that it's very, I've forgotten the exact word she used, but uncomfortable for them to appear before a committee that has no persons of color on it.
Okay.
Share that as an
Thank you very much. Thank you.
That's what they said. Thank you.
Yes. I totally did. Did you stay out in the hallway until we?
That was nice of her, wasn't it? Yeah, she got you.
What are you doing? I didn't want to interrupt it.
Oh, yeah.
Having fun yelling at me for a pink card.
I did enjoy that.
What's to say?
9:30.
9:30, good.
We're doing the caucus at 9?
I would suggest, well,
And.
not,
Okay.
yeah, can we do it at like 8:45? Is that too early?
Yes.
Okay.
I was thinking I was gonna have to be here at 8:30, so 8:45 I'll be happy.
Yeah, so we're gonna have ours at 8:45 to 9:30 at caucus tomorrow. Yeah, I know it. It's getting really old.
I emailed her, but we haven't, we tried Thursday, I tried Friday, Saturday, Sunday, and all I did.
Oh, dear.
They checked back some of the time. And.
Where is Ford coming from?
Can't hear.
I don't know, but I feel like it's getting worse.
It is getting much worse.
Yeah,
Much
and I'm wondering if it's on purpose.
I don't
Getting a
know.
little mad about the food stuff.
Yeah. I'll leave.